Okay, everybody. I hope everybody's doing well. As you can see, I have my regular special guest, Stephanie Joy, Attorney Stephanie Joy, here with me, and we're going to be answering questions. How are you doing? How's the weather in, what is it, East Stroudsburg, Pennsylvania? Is that where you are?
Yes,
And
Northeast PA.
how is the weather in Northeast PA?
Today was cool, and we actually had snow squall. I was
Oh,
sitting here, yeah, it was right before my earlier stuff, and it was like blasting at my window, which wouldn't have been a huge deal. It's still March, but my brand new driver's son had my truck to
oh
go to the gym,
no.
and I'm like, wait, he only got his
Oh,
license 2 weeks ago, so
oh no, that's not a
I'm
good
trying to.
thing.
It's pretty
Wow.
funny.
Yeah,
You gotta
you're in a
love it.
remarkably good mood having that happen. I got to say, yeah, here in Atlanta, it was a nice day. It was like high 60s. Actually, I play a lot of tennis, and so I'm on a team. I don't normally play in this team, but they had me on as kind of for an emergency. So there were two injuries, so I got
Hmm.
called the last minute to go play, and we got smoked. I mean, I'm not bad, but these guys were just killing us. So my partner just couldn't handle anything, and I was able to handle a little bit, but it was not good. So anyway, that put that
One
behind
of
me.
those
So
days.
one of those days, but all in all, at least the weather's nice. So okay, so we've got some questions here, and some of these I don't know the answer to. Maybe you do. So let's take a look. So Michael Robert Jennings asks. If somebody received payments pending a CDR appeal, which means he requested that benefits continue while he was appealing, then he lost, does he have to pay interest on the overpayment? I don't know. I don't think so, but I don't know.
I
I think
don't.
they,
I
yeah.
would say the same thing, Jonathan. I don't think so. Not that I ever heard of. Granted, I haven't outright researched that, but I've
Yeah.
never heard of interest or even penalty.
Yeah. No, I
Um,
don't think so either. I think it's
so,
just they make you pay back and of course you could appeal that. So if you lost the appeal, and just so we're clear, when a CDR is done and Social Security says they move to terminate, you can file an appeal called a request for reconsideration, like you would do in any other type of reconsideration, like a regular hearing case. If you're denied at that for that reconsideration, basically you can request a hearing, and then if you lose the hearing, you can go to the appeals council. So Michael doesn't say whether or not he's simply got denied at the administrative at the recon level or whether he's gone to a hearing or not. So
mm,
Michael, if you're still within the 60 days, if you got denied at recon, that's very common. I mean, statistically, most people are denied at that stage. So I would tell you that, get a hearing. Now, the problem you're going to find, of course, is that if you have benefits continue while you appeal, there's no past due benefits, which means getting an attorney is going to be a real challenge. So I don't know where you are in that, but I would just tell you that exhaust all of your remedies if you can, all your appeals, and hopefully you'll get a more favorable decision there. But I don't think there is any kind of interest there. I would also tell you that I believe that this type of overpayment would be dischargeable in bankruptcy. So this is something else to consider. If it's a large overpayment, maybe something to look at is unpleasant as it may be to think about. That's just something that I think does apply here.
that's good to
Um,
know.
yep, yeah, just Social Security overpayments and so forth are dischargeable in bankruptcy unless they've changed it. And I don't believe so. I did bankruptcy for years and years, and
You were
I'm kind of
saying.
got out of that. But when I did it, every once in a while, 2 or 3 times a year, somebody would come in with a $30,000 overpayment from Social Security, and we would discharge it in bankruptcy. It was never an issue. All right, Carrick is one of my clients. What and wants to know what type of jobs could the VE say transferable skills. The past history of sonographer would be for RFC of lighter sedentary, 56, type 1 diabetes, neuropathy, and back and neck issues. Well, it's the sonographer. I'm guessing that's in the medical field. Is that am I seeing that correctly? Like a some sort of a like a sonogram, like for in a medical facility, like for pregnancy. I think that's what they call that. I believe. I want to make. I'm not sure if I'm correct on that, but I think it's a medical, you know, you working on, I guess, like ultrasound tech, that type of thing. So, as far as transferable skills, there may be some transferable skills within, you know, the medical field, but probably not to sedentary. I'm thinking that's those jobs are going to be light because there's going to be standing and walking, maybe some moving. I can't think off the top of my head any transferable skills to sedentary over something like that. So my guess would be, and obviously what you're getting at, or what we're getting at here, is that the grid rules very likely apply. So if you're limited, if there's no transferable skills, you're limited to a light functional capacity, you're over age 55, then you're disabled under the grid rule 202.06. So, the VE can say, well, there's transferable skills to other ultrasound type of tech jobs, but those are also going to be light and with the same the same kind of skills, but they're light, so it really help you any. What would hurt you would be if there was a transferable skill to something a purely sedentary job, and I don't think that there's any such thing. That's my take. I'm not a vocational witness, but I don't recall ever seeing something like that being determined that there's transferable skills. Um, and obviously, with type 1 diabetes, which is very unpredictable in terms of blood sugar level, neuropathy, back and neck issues, I continue to think that is a pretty compelling argument under the grid rules or under a functional capacity argument. That's my take. Okay. Michael Robert Jennings, again, the person who had asked us about interest. How does somebody elect with a CDR appeal to continue Medicare without continuing? I don't know. I don't know that one at all. I don't know that you can. I think that Medicare is associated with Title II disability, so I don't think you can appeal one and not the other.
Yeah, and he wants to know about continuing it. I don't know that
Yeah,
either.
I don't think so.
And I'm sure the answer's out there. I just don't know
Yeah,
it because, yeah.
yeah. If I'm not mistaken, there is there's a longer period of time you can continue Medicare even if your disability is terminated. But that is just beyond what I do, probably beyond what you do as well, Steph. I don't know that there's.
It is. And I
Yeah.
wonder, is that when you've been ceased for earnings, not for medical improvement?
Hmm.
Is that not, isn't that like 9 years or something? A very long
Yeah, this might be a
spell?
question. Greg Brinkley might be the person to ask. Greg is a former Social Security employee. His email is greg@gregbrinkley.org, GregBrinkley. And Greg might be a person to ask about that. I just don't know because, realize as disability attorneys, we are focused on winning disability cases. We don't really get involved in Medicare because Medicare, understand, is you're approved once you're approved for disability 2 years after your first payment. You become eligible for Medicare. Well, that may be in some cases 6, 8, 12, 15, 20 months after we finish what we do. And one of the things I've learned, and I'm sure you feel the same way, Steph, is you don't want to dabble in things you don't know about. In fact, Steph and I were on a call earlier today with a person who does a lot of Medicare work, and we were discussing Medicare Advantage plans and Medicare supplement plans, and we were both saying, this is really dangerous waters because we don't deal with that stuff, and you don't want to be guessing on it.
And we don't
And
want to be dealing with it. Like
no,
we're
no,
in our niche that we want to be in.
that's right, that's right. So I think that and in fact, one of the things we asked the person who we were talking to about this, who do we refer to for Medicare issues, and she's like, I don't know, because you have people that are out there that sell Medicare Advantage plans. This particular person feels very strongly that Medicare Advantage plans are usually not a good choice for disability claimants. Other people think differently. There's a gentleman that Steph and I both know named Cal Hero. He's got a company called Medicare Mall, and we both like Cal. Nice guy, very sincere, I think an honest guy, and maybe something he might be able to answer for you because he's very knowledgeable about Medicare. But again, in all disclosure, he's an insurance guy, and insurance people obviously are looking to sell policies, which is nothing wrong with that. But if you reach out to Cal, again, info@medicaremall.com is the email. I would just bear in mind that he's got a vested interest, but he's also very, very pleasant. He's also very nice. He'll spend time with people and answer questions. So that may be the person, Michael, to contact is Cal Hero at Medicare Mall, info@medicaremall.com, and just ask him that question. And I just don't know. I personally don't know. We don't really know the answer.
Yep.
Okay. SA is a regular here. If I stayed on most antidepressants less than a month each due to side effects, is it likely the judge will hold it against me? I don't think so. What do you think?
If you are taking, I think the best thing to do, because this happens, this is not uncommon, I don't think, these kind of side effects, make sure you really drive it home with your doctor so the reason why you stop taking them is stated. So it's not like you're just non-compliant with
Yep.
medical
Yeah.
recommendation, like they cause you a significant problem. And doctors are pretty good at putting that in the record, I think, because they want to make sure they don't prescribe it later,
Hmm.
or their successor. I think,
Yeah.
that's the
Yeah.
way
No,
they seem to
I
handle
would
it.
agree. I mean, I think I would definitely make notes of the side effects and realize that some medications, you have side effects, and the doctor may have to adjust the dosage. So, you know, you want to obviously be as compliant as you possibly can, but you're not obligated to take something that makes you nauseous or makes you, you can't think or keeps you up all night, things like that. So, yeah, I would make notes of those and I would let the doctor know. What I tell my clients to do is if you're having bad side effects, use your patient portals, put it in writing to the doctor so the doctor knows, I'm having these side effects. And I would also look up on, let's say, WebMD or some of these other sites, Mayo Clinic site, look at the medication. Are the side effects you're experiencing ones that are known to be side effects of this particular medication? So it's consistent with what the literature shows. In other words, if you're saying this makes me dizzy or breaking out in hives, but there's nothing in the Mayo Clinic or National Institute of Health or WebMD that talks about that at all, that may be something else going on. So I think you just want to do your own research on that. But I don't think they hold it against you. Look, Social Security is very clear. If you're, if a particular procedure is recommended and you don't want to do it because you're concerned about negative an outcome, you're not obligated to do that. You're not obligated to have surgery. I think if your medications are prescribed and they're not, they don't make you feel good, you're not obligated to continue with those either. So, but I think you just need to demonstrate you're doing everything you can to try to make it work, if at all possible. Um,
A
okay,
two-parter.
Michael. Yeah, okay. Michael's got a two-parter. Does a mental residual capacity form help for autism? There's no extreme limitation, but Social Security Blue Book uses extreme. Um, the extreme limitation is appropriate to be handwritten in the form. Okay, so I think there are a couple things. Oh, there's a third here. On my initial application, I had the mental form filled out, meet the autism listing. First CDR got a vocational allowance to say this form could be the reason why. All right, so realize that just a couple of comments here, my initial thoughts. One is a functional capacity form is not the same thing as the listing form. There are two different theories of disability. There are three theories to win a disability case. One is you can meet a listing, and there is a listing for autism disorder. The second is meeting a grid rule, which generally you have to have a physical impairment and over age 50. The third is functional capacity. So, a functional capacity form, and by the way, you can modify those. You don't have to use, if you've got one online or you got one, from a Social Security official website or whatever, you can modify it. But if it was filled out and the doctor was going to handwrite, extreme, yeah, because realize that's more of a listing concept. But yeah, if the doctor wants to make changes to it, that would be that. I mean, my sense is if the doctor is filling out people call it an RFC form. It's really a functional capacity form. RFC is a legal term, stands for residual functional capacity, not a medical term. And doctors are focused on medical, so it's really an FCE form, not an RFC form. But that be that as it may, if the doctor fills out a supportive FCE form, that would not be a reason why you're denied. And realize the forms are only part of the picture. There's got to be underlying medical reports and medical support for it as well. And I understand this is in the context of a continuing disability review. Um, and here too, it may be that if you're at the recon stage, you need to get in front of a judge. And again, not that these forms are going to carry the day, absolutely, but they certainly can help. It just doesn't make sense to me that if the form has a lot of significant limitations, where you could argue the cumulative effect of those would prevent you from working, that the form would have hurt your case. That's just my take. So, okay. All right, and Michael, I realize I got a lot of questions, so I got to get to other people. I'm going to answer one more here. How does somebody with a CDR timely elect to continue benefits within the 10-day period? Um, well, first of all, you need to send something to Social Security. I use Form 795, which is a statement of claimant or other person, and just write on there, I wish to continue benefits during my appeal, and just need to get it to Social Security. That 10 days is a short period of time, and I don't think it's really all that fair, but that's what I use. But theoretically, you could just use a letter, but it needs to be in writing.
Yeah, and I would
Okay.
suggest too, yeah, you don't want to make an appointment for that.
No,
And you're not going to be
no.
calling them for that. It's got to be
All
in
right.
writing. You could probably fax it. I use
Yep.
fax all the time religiously. I mean, and now ever since COVID, they actually publish their fax numbers, every
Yep.
field office, and that is such a blessing because I used to have a person call the 800 number because the SSA offices were not posting fax numbers. They didn't want to
Yep.
get faxes, I guess. This is a few years back, and I had a person who would do all that sitting on the phone for an hour to get through
Oh,
to the 800 number.
nightmare.
Yeah, and I wasn't going to do it.
No.
Um, and so, but I would fax it. If you don't like to fax, don't have a fax, don't want to go to Staples to fax or whatever, you could, I would overnight it. It's going to cost you. That's why I
Yep.
think the fax is good because you get a confirm. And I think that confirm, I've seen nothing to suggest that a fax isn't acceptable for that because you're already a beneficiary. You're not like
Right.
someone doing something weird with your stuff. And you're in the middle of what would be the next logical step, and you'll have proof that they got it within 10 days. And the problem with the 10 days, aside from that it's very short, a lot of times people don't get their mail for 10 days
Yeah.
because the mail is so slow. So
Correct.
it's
Correct.
not, the 10 days I think is too short too.
Yeah, I think faxing is a good idea, and I put in the comments. If you go to ssa.gov/locator, LOCATOR,
Yep.
you can locate an office using your zip code, and you put your zip code in there. It will give you the phone number of the office and the fax number. Now, the phone number may be the 800 number, which, as we all know, has a
Yeah,
3-hour
the phone
wait when
number.
you get.
Sometimes, yeah, a lot of them
Yeah,
they took out their, this is last year
right,
or the year
right.
before, they took out their phone number.
Yeah, but the fax number will be there, and I think, as Steph said, you can put, if you do it with the fax and you have a receipt that the fax went through, at least that gives you an argument. Now, again, we're in a very strange time with Social Security where they're understaffed, and is it possible that you fax in, a request to have benefits continue while you appeal, and it doesn't get properly coded, and they cut your benefits off? And then trying to get them back started is going to be a real pain in the what. But at least if you fax it, maybe even fax it 2 or 3 times over the course of a couple of days, I think you give yourself a better chance to have that happen.
Yeah, you've
Because
got
right,
four fax comms firms that say it reached
yeah,
its destination. It's going to be
yeah,
helpful. And you can also, at the same time, this is kind of more of a old legal habit, but pop something in the mail too. And
hmm
you can have a 795 that says, not only did I fax it and get these confirms see attached, I also took it to the mailbox and mailed a hard copy. So I know
yeah,
they got it, one way or the
and,
other, and for sure the faxes say within 10 days.
and maybe even include a copy of the fax with the receipt in your mail when you mail it in. Just say,
There you
I
go.
sent
Yep.
this in before, but I want to make sure you've got it, and
Yep.
and
Excellent
hope that
idea.
it gets to the right place. I don't know. Um, all right, Jenny, how are you doing, Jenny? I'm glad to see you back. I hope you're doing better. Um, and she has a question in Recon. The DDS caseworker sends call-in letters to clarify memory issues and past relevant work. One of the jobs ended 3/13/20. Can she count this job, especially if the call-in later is dated 3/13/25? Well, realize the look back in a hearing is 5 years, so I don't. I don't think so. I think that well, they're going to look at your onset. Obviously, is going to be part of it. Um, as far as excuse me, what she's getting at is under Social Security rules, the look back for jobs is 5 years from the date of determination. So if it's a recon, it's 5 years from the date of the recon determination. At a hearing, it's 5 years from the date of the hearing. I don't think it's a problem to provide that information. They've got it anyway. But certainly, if they denied the case on a job that ended 5 years ago, that would be grounds for appeal. Um, and it may be that the DDS somehow they didn't get the message that we're now on a 5-year look back. Or you could theoretically object to providing the information by saying this job ended 5 years ago. They may not know when it ended. So you could certainly, provide the name of the employer and say this job ended 3/13/20. Therefore, my understanding is it's no longer relevant. But they look at the DDS level. There's a certain amount of phishing going on. They're trying to get information. If they don't know when you stopped working, they're just going to ask. And so, asking the question and then considering it, using it against you are two different things. So maybe that they're just looking to find out where you worked and so forth. But my thought would be, if you really don't want to get into it, if it was a job theoretically a lot of transferable skills, you can say, yes, I was working for this employer. You have to go what the job was through May 13th of 2020, which is more than 5 years ago. Therefore, my understanding is that's not relevant. But the last time I worked for this employer was 3/13/20. That's how I would probably handle it. Okay, we got 3-part questions here. We got a lot of 3-part questions. Okay, Stargirl. My migraines were triggered by ankylosing spondylitis and degenerative disc disease, leading to weekly migraines. I obtained FMLA, but ultimately lost my 10-year career and 5 part-time jobs. How do I prove in a CE migraines are disabling if the examiner can't see them and may dismiss it? With a CE examiner, I would tell you, well, with the examiner is not going to dismiss it, but hold that thought for a second. And then should I trigger a migraine before the next appointment? No, I wouldn't do that. All right, so let's go back to the beginning here. So there's a trigger to the migraines, okay, leading to weekly migraines. And I think one thing I would do is I would certainly have a log of your migraines, because that way you've got, that's evidence there. All right, the CE, as far as proving, you cannot prove it in the CE. The only way to prove, in fact, I'm working on a case I have a hearing coming up next week, and one of the big issues is migraine headaches. And the way I'm going to prove it is, my client went to the doctor and tried 5 or 6 different medications. And the record, tried this medication, nothing worked. The doctor kept prescribing medication, and she kept going to the neurologist. So I've got a neurologist who's not saying anything that my client is exaggerating the symptoms, and I've got 5 or 6 medications that have failed. So that's how you prove it. The examiner will not dismiss your case. The examiner may deny the claim, but they don't dismiss it. And you've got a neurologist saying the migraines are chronic and intractable, so you have a severe impairment. In the Social Security world, you've got to have impairments that are severe, which is diagnosed and significant enough to potentially cause you to miss work. So I think you pass that test here. Wouldn't you agree? I don't think there's an issue with that.
Yeah,
Severity.
no. One thing I would think, in your records, if you've seen them, Stargirl, has it been noted by your doctor, and have you guys discussed, and then he properly notate, which could be questionable, how often you have your migraines, how long they last, and the fact that they're bedridden, you're bedridden at the for the duration. I see that in a lot of my migraine people, and in the better cases where it's like in every session they'll talk about whether the migraines increased, decreased, and there's a notation of 4 to 5 migraines a month. They can last 1 full to 2 full days each, and then you got like 8 days a month that you're pretty much out of commission by doing the math. And the other thing I wanted to ask you, Jonathan, do you think in a situation like that, it would not be a bad idea to bring in just one, because CEs they're not going to be reading your records. They're not going to spend the time, but a recent neurology specialist report that discussed the frequency, duration, and severity. So it's in their face.
Yep.
Not to be, rude to them.
Yeah.
You're not going to try to be rude, but like they say whether the claimant brought any medical records. And I do tell people, don't you be bringing in your home medical set. They're not going to read it, and you're going to tick someone off. But if you have a really strong thing that's really pertinent to your case, and I'm thinking this might be one, where you bring that most recent, neurology specialist report, assuming the neurology specialist doesn't just say you have migraines. If they go into the severity, which would be duration, frequency, and they usually give, like, if there's photophobia, other sensitivity, they might even say has to go to bed for 2 days, or whatever. I think that might be something that's good for a CE
Yeah,
examiner.
yeah.
If you can
But
get your
but
hands on
don't
that.
but don't but don't be shocked or upset if the CE examiner doesn't look at it, doesn't want to hear it, or doesn't even talk about it in the report. Our experience has always been that CEs, the physical CEs in particular, can be, next to useless. Sometimes the mental health ones can be okay, but it's just part of the puzzle. But most judges
Yeah.
realize the CEs are kind of useless. I also think, that you, like I mentioned before, keep a log of your migraines so that you have evidence that you could theoretically submit at a hearing. This is my log for the last year and a half of the frequency and duration of these migraines, and that's evidence. Now whether the judge gives it weight or not is a different story, but that is evidence. So I think having a log of the frequency and duration, as well as the medications and the effectiveness or lack thereof, is important
Yeah.
too. You also make note of the triggers. As Stephanie said, is it
Triggers.
light? Is it sound? Is it it could be any number of things, smells, any number of things, and then maybe even have a third party fill out a form 795 that talks about when you have a migraine. Stephanie had a migraine yesterday. She went right into her room, pulled the blinds, and was in that room for 24 hours. Didn't come out to eat, anything like that. She was basically in severe pain. It was clear she was in severe pain and didn't want to see anybody or talk to anybody. That can be evidence as well. I mean, I think with migraine cases, you have to be creative and put together. Sometimes it's not medical per se; it can be non-medical evidence. But I had a case a couple of years ago where my client had gone to a headache center again and again and again, and they kept trying different medications. And she was younger; she was like 45, but had been a nurse and had a good career. And she's like, I wouldn't give this up, but for the fact that I'm having these terrible migraines. And so we had all that, the non-medical evidence, the support from the neurologist. But I think the idea of bringing the most recent neurological report, neurologist report that talks about the frequency and duration, and putting it in front of the CE doctor, puts them on the spot a little bit. Where are they going to just ignore a specialist? I mean, probably not. So I think that's a really good idea. And the last part of this question, should you trigger a migraine? No, I think that starts to look like you're trying to manipulate the system. I don't think you want to trigger a symptom. Um, that's just my take. I've never been a big believer in that. I just think that if you happen to have one that day, that's one thing, but don't do anything to trigger. Don't make it
I
worse.
think that could also be detrimental, because if you go there saying I have a migraine because you triggered your version of a migraine, the fact that you were able to get to the CE exam where
Yeah,
you drove yourself, you're out of bed, you're functioning, you're doing something. And I think that could really go against any severity that you typically have with a migraine
yep,
otherwise. So
yep.
you know,
I agree. Yeah, I think that's inconsistent with the migraine that's going to put you in bed with the shades drawn. So yeah, I wouldn't do that. Yeah, and I think that again, if it should come out in the CE that you did these things, that's almost looking like you're trying to influence. It just doesn't look natural, and doesn't pass the smell test. And judges don't like stuff like that. And so if you look like you're trying to manipulate the medical records by triggering something that otherwise wouldn't have happened, I think that's not a good idea. All right, Trish is another regular. Good evening.
hi
Good
Trish.
evening to you, Trish. Okay. Justin, can an MRI that he recently had help even if the brain scan didn't show anything to explain my worst stutter? I'm still waiting to get all hearing. Not sure exactly all that. So what I'm reading is that the brain scan didn't show anything organic, any kind of defect in the brain that would explain a stutter. I don't know that there's going to be. I've never heard of a MRI of the brain explaining a stutter. And maybe there is something, some sort of a, lesion or something like that that might. Um, but not every test is going to show something. I mean, there are, and again, this is a more difficult road to go, but there are conditions, that are not that you may experience. They call them idiopathic conditions, where you may have severe pain in your arm, but there's nothing, that any test shows what's going on. Um, yeah, again, the stutter may be caused by something else. So I don't know that, this rules it out, but I don't think that it means that there's no other cause. And again, I would ask your doctor, what are potential causes of a stutter? I'm assuming you never stuttered before, and then you started stuttering for some reason, and so is there something going on? Could it be psychological? Could it be medication side effects? Could it be some sort of a post-traumatic you know um, uh, effect? Who knows? But
Complicated.
yeah, it's complicated. But yeah, it is more difficult when there's no objective test. But to my knowledge, stuttering is not something that normally you'd see on an MRI.
And I think the mere fact that you have it, assuming it's bad, it would be showing up in possibly other records,
Yeah,
maybe.
yeah.
Or if it's not, maybe you have to get a speech evaluation.
Mm-hmm.
Um, you know, even
Speech
they do
therapist.
speech PT. It's some sort
Yep.
of speech therapy. If for no other reason, even if it doesn't cure it, Justin, and it's good to see you, Justin, um, it will prove that you have it and that you sought treatment for it, you know?
Uh, Now, big picture, let me just throw this out as well. A stutter, in my opinion, is not a inherently disabling condition. It will
Right.
prevent you from doing certain jobs, maybe certain customer service jobs, public, jobs where you're dealing with the public. But having a stutter,
Hmm.
does not mean you can't do a packing job or a laundry marker job, things like that. So be aware that that's probably on its own not enough to win a disability case. Um,
Which is true of most impairments, right? Most impairments don't eliminate all 12,000 jobs, right?
mhm.
So we have to, I always describe it to people, we have this big bowl of 12,000 occupations. Maybe it's 11,995 now, I don't know, with the
Yeah,
removal of a few. And we have to carve out each and every one way or
yeah.
another, whether it's through RFC or through the grid application, carves out
Hmm.
some, right? I mean, it's a lot. So it's one of the reasons why we often say don't hang your hat on just one impairment. Yeah, because that'll take out maybe 80%, but you still have 20% left. Or let's say it takes out
Potentially, yeah.
98%, but you still got 2% of the jobs left. You have to, it's why you have to go after sometimes those smaller impairments that,
Yeah.
you know.
Well, look, I mean, another way to look at this is that when I'm talking to a potential client, I'm looking at everything through the lens of how does this problem prevent this person from working? Because you could have three herniated discs, type 1 diabetes with poor control. You could have a DVT blood clot in your leg. It doesn't matter if it doesn't stop you from working. So you don't
Right.
win with the diagnosis. You win because of the effect of that. And when we talk about these 12,000 jobs, there is a resource that Social Security sort of still uses for some ridiculous reason called the Dictionary of Occupational Titles, which identifies those jobs. You go to occupationalinfo.org if you want to look at it, and they're kind of backing away from it a little bit. But every job that exists is theoretically is in this book, and there are some simple sedentary, which means kind of sit down, unskilled. They call them SVP1 jobs. SVP stands for specific vocational preparation. And these are jobs that a person, could come in off the street and do without any training. And they're not a ton of them, but there's 40 or 50 of them. So literally, if you have a pulse, you could do an SVP1 type of job. And so, yeah, we got to eliminate that in many cases. I mean, when you get to the grids, it becomes a little bit easier. But for most people, we have to eliminate all those kind of jobs. And every impairment may eliminate some. So a stutter may eliminate, of the 12,000 jobs, let's say 40% of them involve communication with the public that has to be, reliable. That may eliminate those. But what about the other, 60% that don't require that? So that's the way you got to look at it. It's really about, vocational the vocational implications of medical problems, and more specifically, specific medical problems. So, you've got a kidney disease, that may cause you to urinate 3 times an hour. That is a vocational problem. So that's the way you got to look at it. These are all about vocational issues.
Yep.
Okay, Dennis says he's 57. I hope no CDR. People ask Steph all the time on the live stream. Do I have to worry about a CDR? I'm 55. I'm 58. I'm 60. My sense is that unless there's earnings showing up in your earnings record, when you get to 50 or 55, you're not their prime target. I don't think that's something you're going to see a ton of. Doesn't mean it wouldn't happen, but the 35-year-old, the 40-year-old is going to be much more of a target than a 57-year-old. Wouldn't you agree?
I would agree, but I think that might also be because they maybe have a 5 to 7 year diary. You know what
Right.
I mean?
Could be.
That if they had the same impairment at 40, they wouldn't have a 5 to 7, they might have a 3. So I really think it's not so much that they're not targeting them. The rules change as we age. Like when we pop into 50, you know, we've already had, they know that there's the grid. So that's going to probably internally somehow, I'm thinking,
Mm-hmm.
affect how they put the new diary date on. I do see a lot of 50 somethings that they get a short form. Sometimes they get a long form. Don't get me wrong. Um, but also, don't they do that thing where they literally just, it's not that you didn't have a quick review, they bypassed it kind of, like, yeah, you're on the 5 year and we decided we don't need to review you. And it's not like they
Mm-hmm.
ordered the records because someone, would say, did they get my records somehow? Like, no, they can't. They would have to get an 827,
Yeah.
with
Which
the,
is medical authorizations with
yeah,
827. So what you're saying is that you may be diaried, and I hold that thought because I have a question about that. You may be diaried for a 5 year review, but 5 years comes along and they decide not to review you because some algorithm in their system said this 57-year-old with 3 herniated discs is not likely to have medical improvement. We got to spend our time on other things. So I think
and
that's
maybe,
probably
yeah,
more
they look at
computer.
the past work, and now that past
Mm-hmm.
work is now out of the I mean, there's so many
Yep.
factors now, right?
Right.
That would
Right.
that would change it. So
Yeah, that's actually a very good point. That if you were approved, let's say 5, 6 years ago, when there was a 15-year look back, now it's a 5 year look back. So when they're looking at it again, they're saying, well, if we did this again, this person would meet would there be no past relevant work as opposed to past relevant work? We had to decide there was no transferable skills. That makes it even less likely this person would have the capacity to work. And again, if you put in zeros as far as earnings in that short form, that may also do it. Now, you talked about the diaring, and I've had this discussion with a couple of people. Um, is that something that we can find? Is that available
you know,
to a claimant, or how
I
do we
I
know how
always
they're
understood
diaried?
that they can call. Now, granted, if you can get someone
Mm,
to answer the phone, it's probably been
right.
bad last few years, but that the SSA, if you get someone, they should be able to look that up. And I bet I would like to think even the 1-800 number could look it up. Can't get through to the 1-800 number now. I actually
Yeah.
tried it the other day, Jonathan, just
Mm,
for
yeah.
shits and giggles, and it disconnected me after telling me there was at least a 2 hour wait. Sorry.
Yeah.
And it's not
Yeah.
even like you can wait for 2 hours. They won't let you.
Yeah.
And I don't know. It probably varies. They put on a certain outgoing message, I guess, at certain times. And,
Yeah.
there was no callback option where they could call you back. There was no, um, it's just terrible, for I don't
Yeah.
know how long now, but I just was double checking to see if it had gotten better yet. And it
Really
hasn't.
good about it. Yeah.
But
Now, actually,
yeah,
I have a client, longtime client of mine who we got approved, and he is very concerned about a CDR. Although I told him he probably shouldn't be because I think he's not going to be reviewed. But he said that he got a letter. There's some codes on the address bar that he did his research and he figured out what those codes stood for that told him where he was in the process. Um, I don't know if that's a bit, and I've
there
really
was
not.
something. There was something. Um, I don't know if it's even related, but I know when I've finagled through some CDR notices with people in the past, and it's been a little
Mhm.
while, there is a code. But if they're getting the CDR, they probably already know when their diary is. So I'm not sure what.
Yeah,
I'm
well,
trying to remember what
he
the
just,
code was.
yeah, what he said was on the address. When you look over the address, there's a series of letters and numbers that he figured out how to translate it. And I got to give him a call to find
There's a
out if he could.
website. Someone had put
Oh,
up a web. Yeah, it was someone who had put. That's where I think I got my information
okay.
when we were kind of haggling through it. I have no idea where it is now. It wasn't like an SSA website. It was
No,
somebody
somebody
else's.
else did it.
Yeah,
Okay. All right.
yeah,
Well, I'm going to try to track that down because I get a lot of questions about that. And I really would like to
yeah.
know. Um,
Hopefully one day they will put it right in the award letter.
yeah, you would think that'd be nice.
Just put it in there.
Yeah. Well, I mean, I wonder if you could probably do a Freedom of Information Act to get it, although that takes a long time. But yeah, might
Yeah.
be kind of interesting. It would be. I think it's really only fair to be transparent about that, so you know. but
I remember there
fair.
being something put out a few years, this is a few years back, like at least 5 probably, where it was when some other SSA changes had come about, and they talked about, I think it was about CDRs and the timing being transparent.
Hmm.
Um, and then that got sidetracked, over the next years, and so it never
Yeah.
happened, or at least not overtly where we could see it. I do know sometimes the ALJs will recommend a certain diary,
Yeah. I've
particularly if
seen
it's a
that.
short one, I think.
Yep. I've seen that in a decision. I recommend that this case be reviewed in 1 year because the claimant is undergoing surgery in 2 weeks and we expect a full recovery. But
Yeah.
that is kind of rare. But I will see what I can do to find out those codes because will be something useful to know. All right. So Trish says hello again. So Trish Wade says just hello again, Stephanie. So
Yeah.
all right, Jenny Joe. The other two positions she was inquiring about, one was never held; it was put in by mistake. Those were performed 1 or 2 weeks. Okay, so Jenny is asking about past relevant work. Obviously, if it was not done, then that's not past relevant work. And then something you did only 1 to 2 weeks would not be past relevant work because it's too short. They're not relevant and they would not be considered. And again, if you got a denial, realize you can get a denial for any reason, but I can't imagine that Social Security would put in a denial notice that we relied on transferable skills from a job that you did not do or that you only did for 2 weeks. Could it happen? Yeah, but I think that certainly a judge wouldn't do it. But you can't control what the adjudicators do. But I think that's pretty unlikely. It's not relevant. Okay, Teresa. My question is about needing to schedule a telehealth and physical. Any advice what to expect? How long to different outcome? So we're talking, I think, about the consultative evaluations, and are they still doing them by telehealth? I thought they went back to live. I don't know. I know at one point they were doing only telehealth appointments. Maybe they still are doing them. Um, as far as what to expect, there is. There's a doctor named John Foster, who actually was on the live stream with me a couple months ago. He's got a website. He's got a YouTube channel. Just type in John Foster, Social Security. It'll come up, and he has a whole series of videos about consultative evaluations and what to expect and how they work. And he is a little unique in that I think he takes it probably a little more seriously than a lot of the consultative doctors. A lot of the doctors who do consultative exams are, I call them industrial clinic doctors. The insurance companies use them to deny claims. They'll do 30-minute exam and they don't say anything or they, just fill the same report in over and over and over. So, you have to cooperate with them. If they ask you to walk, back and forth, you do that. Realize they will be watching you from the, possibly from the waiting, watching you walk in from the parking lot into the waiting area. If they see, I've seen a number of reports that say the claimant, when in my office, struggled to get off the exam chair, claimed had a severely and swollen right knee, but watching her or him walk out the door to the parking lot, there was no limp at all. So be aware that they'll be, they could be watching you in that regard. Again, most of the doctors who do CEs, physical CEs, are doctors that insurance companies use to justify denial of benefits. That's just the way it is. The psychological CEs are typically real psychologists who do this to make a little extra money. So I usually find that the psychological CEs have a little more value to them than the physical CEs. That's my opinion. There are doctors who take it a little more seriously. Sometimes they'll send you out for a specialist. That's typically going to be a little bit better. Let's say it's a cardiologist or a neuropsych evaluation, something like that. But the normal run-of-the-mill industrial clinic doctor, it's a crapshoot. That's my. Would you agree?
Yeah, I would agree. I do think they're still doing telehealth for mental.
Are they okay?
Yeah, because I keep getting things like, we want to know if your client would agree to
Yep.
telehealth versus, and I'm like, I have a feeling they would.
Yeah. Yeah.
um,
Okay. All right.
and they also ask how long to determine an outcome after these are completed.
Yep.
Typically, didn't you find that usually within a few weeks you would have an outcome. It's a
Well, I
little
mean,
different now, maybe, but
yeah, the exam. Realize what's happening is the exam is usually updated, within a few days. So it'll be in the exhibit file within 4 or 5 days. And if you have an attorney, we can get you a copy of it. Then the adjudicator has to look at it, read it, send it off to a medical specialist to look at it, and come back to the adjudicator. And if there's other medical evidence that's being gathered, it could be 3 or 4 weeks, it could be 3 or 4 months. It just depends on how busy they are and what else they got to do. But there's really no correlation, in my opinion, from when you have a consultative evaluation and a decision at the administrative, initial recon level. It just really depends, because if the CE was ordered early, the other medical has to come in, and that could take 8, 10, 12 months. But if it's done
uh,
late, it could be,
see,
faster.
I typically see the CE ordered after the bulk of the medical records are received. And I always was under the impression, and I know every area can differ.
Yeah.
I was under the impression that it was because, if they're going to be able to award that person, maybe it's a listing based on the medicals, they don't
Hmm.
need a CE.
Yeah.
So I don't know, but
There was,
everything
could
changes,
be.
and the different states, the different territories, kind of vary. But
Yeah.
so
Now I
ours
will
used to
say,
happen like within
yeah, no, that
three
makes
weeks.
sense. I mean,
Yeah.
yeah, because I think one of the things that Social Security is very concerned about is saving money, and every time they order a CE, that costs them money. So
Right.
if they can make a decision without the CE, that they will. Although I will tell you, I've had a number of cases recently that are, I think fairly strong cases. There was no CE at all. And I don't recall ever seeing this many cases without a CE. So I'm thinking that, there may be, orders from on high to reduce the number of CEs, because as a cost saving measure, that could be going
What
on
was
too.
were those cases that prevailed or were denied?
Well, these are cases that I'm trying now. So some of them have been approved, some of them not, and there's just no CE at all in there. Um,
I mean,
so
you're at hearing. You're going to hearing.
I'm at hearing, right? So I mean, I usually have pretty good cases, but um, these are not cases. They were denied, obviously, at initial recon, but there's
Wow.
no CE. Yeah,
I
it's
never
it's
see it. I have
you see
not
them in
seen
most of your
that.
cases. Yeah,
I wonder, do you think the judge, all right, I'm just tossing this out here, guys.
yeah.
Do you think if the judge is going to deny, he probably has to order a CE before he can do it?
Well, I know that
Maybe.
some judges. I had a case actually not too long ago where the judge basically, it was a bizarre situation because this judge has a very high approval rate, and she's like, "Well, there's no medical source statement in the file other than the CE." And that was used at the by initial and the state agency to deny the case. Without something else, I'm going to have to reach the same conclusion. I'm like, no, you don't, because that's your job as a judge, is to look at the evidence critically, and that's one piece of evidence. But having are you punishing a claimant for not having a formal functional capacity evaluation, which is a $2,000 expenditure?
Right, it's
You know,
not
and
their obligation. Right.
right. So I don't think it's her obligation. And so I put it on the list serve, and people came back, no, that she's just going through the boat. And so anyway, she basically said she'll eventually approve it, but she's got to go through this process. So she sent it out for a post-hearing CE that was, I mean, you talk about useless. I mean, basically, this doctor didn't say anything, and so I objected to it and demanded, a right to cross-examine him because he didn't say anything, and it made no sense. And so I'm waiting to see what happens. We haven't got another hearing scheduled, but
Mm.
some of my colleagues say she's going to go ahead and approve it based on the other evidence. But yeah, I mean, I don't think that you can demand a functional capacity evaluation and rely on a CE to deny a case, especially when CEs are so inherently flawed.
Yeah, right.
Um,
Interesting. Very interesting.
all right, MB Hole. Good evening. Good evening, MB. Harold. Uh, Agents to money. I'm not sure what that means. Hello, I'm 61, applying for disability in 2022. I've been turned down twice with uncontrolled diabetes. Some essential tremor, not I think you meant essential tremors. There's a big difference there, and in need of shoulder replacement. Um, you were a bus driver. Uh, Crickets. Now I'm homeless. Handsome hero fears his own waiting on a judge. Okay, maybe there's some code in there. When we got more here. Um, Okay, well, same thing before. Okay. You applied for disability in 2022. You've been turned down twice. Have uncontrolled. So again, I hope that you requested a hearing. Uncontrolled diabetes can obviously cause a lot of functional issues. Essential tremors is what you mean. That again is not going to be enough probably to disable you from every job, but certainly jobs that require fine motor, manipulation would be a problem. Need of a shoulder replacement. Obviously the medical record is going to tell the tale, but I think there's probably enough here to make a grid rule argument. Clearly, you can't go back to driving a bus with the tremors and the diabetes, and there's probably no transferable skills within that RFC. So I think you probably meet a grid rule at 202.06, but you got to get to a hearing, and that's so. I hope you've appealed and you're going to get a hearing.
And he has to reduce himself to light or sedentary by those medical records, which probably you can with the with those things.
Right. And the diabetes, even though it's not exertional, it does, I think, have exertional implications. I've won cases where I argue that, uncontrolled diabetes and blood sugar, fluctuations would prevent somebody from, safely lifting more than 20 pounds occasionally, or standing safely more than, a couple hours. And
plus he's got a shoulder replacement.
Shoulder, right, which is going to
That's
impact
going to affect the lifting,
right.
And that's part of that.
As might the tremors too. That's right. Okay.
Hey, Harold, if you don't have a rep, if you're heading to hearing, you probably should get one. I'm just thinking to help, work all that up together. And they might even say, hey, if you can go to the, a doctor. I mean, did you say you were homeless though? Do you have Medicaid? Are you going to the doctors? What's going on?
Yeah, I know this is, see, a lot of times we get, and this is not atypical, where somebody like Harold has gone through probably his savings. He had a good job. He was getting along, and now because of these long delays is homeless, and it puts people in a really, really bad situation. And you got to just stay the course. Unfortunately, there's no other alternative other than to just stay the course. It's difficult.
So you can get out.
And I think this is just one of these areas where the long delays cause a lot of problems, causes real life, struggles that are just
absolutely.
Really unfair.
I mean, homeless.
Yeah.
You lose your home.
Vince says hello. Mark is one of my clients. We have a hearing tomorrow, and we talked today, and I'm glad that we were able to reduce your anxiety. We went through all the questions he's likely to get, and I'm glad to be part of your team too, Mark. And we will do what we got to do tomorrow. Hopefully things will work out. So I'm hoping so. Off to bed, get a good. That's exactly right. You should absolutely. Well, good night, and I will talk to you tomorrow.
Yes, rest up, be ready.
Yeah, actually, I have 3 cases scheduled for tomorrow. One of them is Mark, and that's I think a pretty good case. And then the second one was a lady that I did a brief on, and I got a call from the judge's office that they're going to grant it on the record, which is like, hey, love that.
Beautiful.
The third one is with a judge with the second lowest approval rate in the country, like 12%. And so it's not going to. I'm concerned about that. Obviously, good case, but bad judge. So we'll see what happens. Okay, let's see. We got Laura says, if I file for disability from 2019, that says an onset date. For 2020. Let's go from there. Okay, so she basically filed for disability, alleged an onset date 2019. Social Security says we can't get the records before 2020. Should you amend your onset date? Steph, what do you think?
I say no. They can give her. They can award her whatever date they want.
Yeah.
They're not bound. They're not. It's not where they have to take your 2019 date or nothing. They have the power to, and they do it all the time. Give you a later one. But I also wonder, why is there trouble of getting records?
Like 6 years ago.
You can only get them after 2020. That's only 5 years ago.
Yeah, not that long. I agree. Now, you may have the records. So if you've got the records, then you can submit them. That would be one thing. A lot of times medical records after that date may refer to older records. For example, it's very common. Like I have a couple of cases I'm working on where my client had let's say, a surgery in 1987. Well, I don't have those records, but it's referenced in the record. The claimant had surgery in 1987, and the MRI shows healed scarring or healed bone or whatever it may be. So yeah, just because you don't have those records doesn't mean they can't. There may be other records that reference that date. Now, let me make another point here. When you apply, first of all, you need to know your date last insured, because that could be a relevant factor here too. If your date last insured is 2019, then you wouldn't want to consider amending to 2020. Now, hopefully that's not, but that theoretically could be a potential issue. Second thing is, when you if you look at the date of application, so when you applied, you can only get paid 1 year prior to your date of application. So let's say you applied in 2024. The earliest you're going to get paid is a year prior to that. Add the 5-month waiting period. So let's just say 12 months plus 5 plus a partial month. So let's say 18 months. Really, an applicant, if you allege an onset date more than 18 months prior to your application, it doesn't matter, assuming there's no date last insured problem. So you might want to look at changing the onset date, now or at a hearing if the your application was, more than 18 months ago, or less than 18. What am I saying? The application date was 18 months ago, or less, because anything more than that, you're not going to get paid. Or I'm saying you have an application date, you go back 18 months, and the onset.
They're never going to pay you all that retro.
Yeah, they're going to pay. Right, they're not going to pay retro.
The more recent your application date is, the less going back.
You're going to get paid. Yeah, I didn't explain that very well. So if you applied in January,
it gets a little wonky with
it gets
time.
Right. So you applied in February of 24, you can get paid from February of 23, and then you can go back another 5 months to use up the waiting period. Is what I'm getting at. So let's say you can use October of 22 as your onset date, and then anything before that doesn't help you because you're not going to get paid anymore. So it might be something to look at. But I would agree. I'm not a big fan of voluntarily changing things because they can't be bothered to get the records. That's kind
of make the bad decision if they have to.
Right, and especially if you've got
gained from it.
Yes, right, and then look, especially if you've got those records, or you can come have somebody get them. Look, you always want to be your own advocate in these situations. So maybe they requested the records and they couldn't find them. Maybe your doctor closed practice or merged his practice, and where the new place is. You make a couple of phone calls, you can track them down. You just never know. So,
or it's sometimes it just happens where they're not getting them from the doctor, whether the doctor didn't get their request or they're just slow. I would, if I were you, call that doctor's office and say, you got a request from SSA for my records. Mm-hmm. Or if you don't want to say that, you could say, I need to order all of my records. Do you have they'll make you sign a release. And if you're signing theirs, depending on your state, they might actually be charging you for the records. There is a whole different arena about the high-tech HIPAA way you can do it for a dime, practically. Yeah. But that's, a longer explanation for a different day.
Right. But the bottom line is that don't just accept that they couldn't get them.
Right. And you're free to go get your own records.
Yeah.
Always.
And we both feel that 5 years is 15 years is one thing, 5 years, so they should be able to get them.
Yeah. I've always heard the 7-year date, back in the day when they kept, come on, Jonathan, didn't you get any of this? We had a warehouse fire and all the records are gone. I see that all the time in practice. And I'd be like, seriously, there's a lot of warehouse fires.
Yeah, a lot of warehouse fires. I've never heard of them. Well, look, as lawyers, we're supposed to keep our records for like 7 or 10 years. In fact, everything now is paperless. So I had a storage facility. We had a storage facility that we were paying monthly rent on. And finally, after, 7 or 8 years of non-use, went and shredded all that. So we copied it. We copied the stuff we needed, shredded the rest of it, and, don't have to storage anymore. So
did the exact same, always had they were always scanned in. So I wasn't ever reliant on maybe the first couple of years, but after that I started scanning everything in, and then I got rid of paper files. But I did have quite a few years of bins, and it was a pleasure. I actually hired a company to come to the place and shred it.
Yeah, we actually we got a couple of high school students to go over, and we loaded up the car and made all these trips, and then we got these like the shredding bins, and they look like big garbage cans, and just dumped all that stuff in there,
Yeah.
and it was gone, and that was great. So yeah,
It's interesting too. They have these trucks. It was like a veteran owned
like a mobile shredding thing.
yes, and
Hmm.
it was through some like veteran they refer to veterans who have their own small companies.
Right.
They had a truck. It wasn't cheap, mind you.
Yeah.
Um and it was incredible. I mean, it was like a bit, it's almost like a garbage truck almost,
Yes.
where it's
Yes.
like,
Yep. That's right.
and it was the truck did the whole job right there. It
Yep.
was,
Yep. You
so
just
you
dump
don't
it all in
actually,
there.
they don't take it away. You don't get in the
Right.
bins where you're not sure if it's actually getting
Right.
shredded. They do it right in
Right.
front of you.
You can.
So
You're right. You see it. That's exactly
yeah,
right.
it was good.
It's loud. Yeah, it's loud. Okay.
Yeah.
Kevin says he watched one of your videos and asked if you'd hook up, and boom, it happened. Too great.
Where
Okay.
I remember Kevin. Yeah, it was actually a live Q&A that at
Oh, okay.
lunchtime, and he did mention, and at the time I didn't know I would be popping in here. So,
Yeah. Okay.
but I
Cool.
think I did tell him. I'm like, I think he's coming to a Zoom we're doing with colleagues
Yeah.
today.
There you
So
go. All right.
things
So
change,
Jen,
Kevin.
there you go. Jen is my paralegal in Lincoln, Nebraska. So Jen, how's the weather in Lincoln? I know it's Steph, you were saying you had some snow, so I'm guessing in Lincoln it's probably
Oh,
still pretty cold. Um, okay. Willie says, what is the
Willie.
percentage approved at stage one? You mean initial application? What is it, like 35%? I think in the last waterfall chart.
Last like flow. What do they call it? Waterfall chart.
Yeah,
I
yeah.
think I saw that it was about. I think maybe it was even. This is a couple years ago. 38%
Hmm.
at
Something like
that
that.
time,
Yeah. But a lot of those are listing level cases. These are not,
for sure.
these are cases, person's got terminal cancer, they've got, their heart transplant list. So it's a little misleading because these are
It's
people
not going to apply to most people, that number,
right.
right?
These are really, really serious. Jen says that Mark, she's thinking of him because we're getting ready here tomorrow. Um, Jeff Brown. I'm currently working. If I go to pain doctor, he puts restrictions. Am I required to give my employer a copy of these restrictions? If he fires me, can I then apply? I can't speak to, I mean, as far as the restrictions, I don't know, depending on the state you live in, what your employer's obligations are. Now, there is something called the ADA, Americans with Disability Act, that in theory, employers in a certain range in terms of business size are required to make what they call reasonable accommodations. That's about all I know about the ADA. So I think that that might be worth a little more research, or maybe calling an ADA attorney to get some guidance on that. You're not required to give an employer. The question is, do you want to get an accommodation? And of course, if you stop working, you could then apply, assuming, and this is a question people always ask: should I apply for benefits? Or should I keep trying to work? My thought is, if you can work, you should work, because applying for benefits is a 2 to 3 year process, and you may not win. But if you work, you're getting paid every week. So the longer you can work, the better. So I wouldn't look for a reason to apply for disability unless you reach the point you simply cannot work.
Right. And also, so much, Jeff, will depend on your vocational profile and your case. Like, you can't, even if you can't do that job, he puts you on what we would call maybe light duty or something, and maybe it jives with even sedentary. But if you're not
Mm-hmm.
in the right kind of case where being limited to sedentary, you can still win, or light, right? So it's
You're like, how old? We don't know how old you are. I mean, if
yeah,
you're 57, that's one thing. If you're 47, it's totally different. So,
it's worlds apart. It's worlds apart.
okay. All right. If I get approved for SSI and I'm married, but we're living separate, two houses, will that hurt both of our SSI? I don't. I don't know.
I have a thought on that one.
Yeah. Okay. Go for it.
Um, SSI, so we're not talking Social Security at all, right?
We're talking supplemental security income, which
Right.
is the means tested. Not based on your earnings records, based on you're being disabled. Same definition of disability, but you don't have enough credits to qualify for SSDI.
So the marriage restriction, because two live cheaper than one, is generally
Mm-hmm.
when you're living together and not estranged, and you also can't be giving each other spousal support. You know, like in terms of people can be like, let's say it's one spouse is filing for SSI, the other one isn't, and I know that's not your situation, Terry. Um, and so the one that's got a job moves out, they're estranged, and that person is not giving spousal support. So your income, the remaining disabled person's income is nothing or very low, you know, and they can still apply for SSI because and you have to explain that I'm married but separated and I get no support from my spouse. We are estranged. Can't be living under the same roof, and they're probably going to, you know, inquire as to potentially proofs. I'm not sure, but under that situation, you can get SSI. If the two of you are, if you're separated, two different houses, like you say here, and you're both seeking SSI for
I think
disability,
one is on. I think the wife. I think his wife or husband. I'm not sure. Has already got SSI, um,
and
and
okay,
Terry. I'm not sure if Terry, if you're a male or female, but let's assume it's a male. So if Terry is approved
is
for SSI
applying.
and his wife is already getting SSI, so now you have two separate households, both receiving SSI. Are they going to look at those as one household or
And do
two?
that maximum. I think you can get away from that if you're living separately
Yeah,
nobody's giving anyone uh,
support. Yeah.
right. Like,
This again
so
might
you're
be
not living together like you're married people anymore. You're actually kind of like
right,
acting and behaving and financing
right.
completely
Yeah.
separately.
And again,
It can work.
I mean, I know that in the bankruptcy world, if you had a spouse but you were separated, they would not treat your spouse's income as part of yours. So there's certainly in federal law, that's generally the way it's done. Now, again, Social Security has got its own rules, but I suspect
Right.
that's the way it works. This again might be a question for Greg Brinkley because he, I think, probably dealt with that kind of thing. And you know, he might be worth an email or a call to him, Greg at gregbrinkley.org, just to see what he thinks about that. Um, Zippy, if you have overpayment, no fault of my own, overpayment plan will change with EW. Not
Are you
sure.
talking? He's probably talking about the new
Yeah,
um the default returning after like
new
a 3 or
rules.
4
Yeah,
month
yeah.
reprieve from it. If you already have a payment plan,
I
I
think you're
understand they're
good.
keeping those.
Yep, I
It's
think
only
so.
for new
Right,
overpayment cases that they're
right.
um
And
you have to
I think what's SSI only, right? Isn't or is it both SSI and
I believe it's
both?
SSI is going to remain 10%. They're not changing that one because you're
No.
SSI, you're poor.
Okay.
It's the SSD or retirement or whatever that you've been overpaid on. And it's not and you can still apply for a better payment plan. It's just that the
Yeah.
default until you choose to prove otherwise is
Is
that you can afford to pay it back.
yeah, yeah.
Yeah.
That
So it kind of gets people going to like, all right, I can't just assume they're not going to barely charge me and I can walk away
right,
from this. Now the
right.
impetus is on people to show, oh yeah, I really would be very hardshiped if I
Yeah,
had to
so
do
that's
this.
an important point because you see in the news that all the reports are Social Security has changed this policy. They're going to take 100% of your benefit, and you're going to be in the street. Okay, and what Stephanie's saying is that's the default, and you can apply for a better terms. Now the issue, in my mind, is going to be, at what point does your application for better terms, does somebody actually look at that? Are you going to be without money for 5, 6, 7 months? That's where I think the problem is. And that's where, honestly, if you have that type of
Yeah.
situation, contact your U.S. senator or representative and say, look, I need this to be expedited because this is going to cause me extreme hardship.
Right.
And that,
Right.
that would be what I would
Hopefully
do.
that's going to be one of those priority things. Um, I don't know what did they do before? Do you even know? Like they were short staffed, you know,
Yeah. I mean, I suspect there are
all
probably
the years
employees.
later. Was it screwing
Yeah.
people in terms of, and the default was
Yeah.
100%. So I'm just wondering.
Yeah, I don't. It's a good question. I don't know. I mean, I think that
I don't know either.
in the recent past, they would get to those requests for payment plans pretty quickly, but now staffing is going to be a problem, and I think that you can't assume anything honestly about Social Security at this point because it's in a lot of turmoil. I think it'll settle down at some point, but right now it's a lot of turmoil. And the problem is if you happen to be caught up in a situation where you have an overpayment and they just sort of plow ahead and take your entire benefit and you apply for a better plan and nobody looks at it,
Nobody
you
looks
could
at
have a
it.
really, really hard time for a few months, that's again where being proactive, I would, if you get one of these, I would immediately request a plan, a payment plan, and then contact your elected representative and get some
That's not a
muscle
bad
behind you.
idea.
Yeah.
Just until we find out if they're, if it's going to be, if the staffing is going to be one of the priority places.
Yep. Yep. I would agree.
I don't think it was before, but hopefully it will become.
Yep. Okay. How long after it gets assigned to an ATL person does it take? I was told it was in Baltimore. Marie, you're going to have to give me a. Do you understand what she's asking?
ATL?
So is it maybe
Oh, I
she's
think maybe she means an adjudicator. Because that's who
okay.
we get assigned, right? Adjudicator,
Okay.
at the
Well,
DDS
Baltimore is a
maybe.
payment, but the Baltimore is the payment center, is it not?
But
Or
well, they also have don't they also have DDS there
yeah,
for
Marie, you know what? We could speculate. Put another question. Try to explain your question a little more thoroughly. I don't think we understand it. We don't want to give you wrong
what
information.
is ATL? Maybe that
Yeah,
would help. Right?
yeah. And what is you say? What is? And what are you trying to find it assigned to an ATL person? Just let us know more what you're asking, if you could. Um, can you talk about applying for SSI, SSDI with a low IQ? What do you think?
Oh, 62.
Let
I
me
have
look up.
not researched that in a long time, but why
Yeah.
does something about 70 ring a bell?
Well, because I think of the listings, if you have under listing 12, I'm looking it up right now. If you have a full scale IQ, um, I believe of 70 or lower, and some other significant problem, I think that is a listing level impairment. That's what I'm thinking.
Yeah, grab
Um,
that listing,
yeah, let
Heidi.
me see if I can find it. Uh, let's see here.
And remember to always include any physical problems you have too,
Yeah, intellectual
along with that.
disorder.
Yeah.
Okay. All right. So, yeah. Okay. So, listing 12.05 basically says a full scale IQ of 70 or below, okay, and with significant deficits in adaptive functioning. Yeah, that's a listing level, potentially a listing level, um, you know, intellectual disorder under listing 12.05. Um, but it doesn't. But there's if you look at that listing, there are other functional limitations that have to arise from that. Um, so yeah, anything you've got going on physically or mentally other than that would be helpful, and you need to have evidence that talks about the functional issues that arise. When you look at the listings, every listing has kind of a mini functional capacity part to it. Maybe just a couple of questions, but it's again not just a diagnosis. There's got to be some functional issue that arises
Right.
from it. And this one in particular talks about a full scale IQ, and significant deficits in function like understanding, remembering, and applying information, interacting with others, concentrating, adapting, managing oneself, and that the disorder began prior to age 22. So there's, it's not a slam dunk. You've got more stuff in there here. There was something
Oh,
else I
the
could
age
swear.
22 they put in there.
Yeah, that's new. That's fairly new.
So
Um,
that's like, wow. So if you weren't really,
so the question's like the question comes up if your IQ was reduced because of some sort of a trauma, that listing wouldn't necessarily apply. You might have to look at listing 12.15. But yeah, look at the listing 12.05 and see whether that applies. This looks like it's more of a lifelong kind of thing, but that part of it is kind of new. Yeah, that's right.
wow.
So yeah, just always should. Yeah, yes. Again, a lot of those cases are picked off at initial and recon, so we don't really see them very much.
Yep.
I don't recall the last time I saw a very very low full scale IQ like that that
Yeah.
got to a hearing. So um, um,
Yeah.
you know what?
Kevin.
Okay. Well, we know what you're doing. That hopefully that doesn't count as substantial gainful activity watching our live streams here.
Yeah.
Okay. Um,
Oh, Kevin, you need knee surgery. Ding, 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 ding. I think if I'm remembering right, Kevin, um, will the fact that a doctor stated I need knee surgery be helpful? And I said yes, that you are a
Hmm.
surgical candidate shows the severity of the knee condition versus mere subjective complaints of pain, or even complaints of pain, which I'm sure you have, and not being a candidate for surgery because it's not severe enough yet. So I think whenever they think that you should have surgery, whether or not you get it or not, it is
Yeah.
a good step in the right direction.
Yeah, that's always an important factor. If you have a doctor saying you're a surgical candidate and you need surgery, that not takes it up a notch as far as the level of severity. And
Yep.
absolutely that makes a big difference because, whether you have the surgery, like you said, whether you have the surgery or not, it is, doctors are reluctant, believe it or not, to cut on people because you just never know what's going to happen. And they, especially like in back cases, they try everything else first. You know,
The
physical
spine.
therapy,
Yeah.
yeah. So pain medication, that sort of stuff. All right, sweet candy. Got denied last week for the third time. Can I do an appeal with a lawyer? I'm 53 years old. All right. Again, did you get denied at a hearing? Third hearing? I think it's kind of hard to answer.
Or is it,
You
or
can
was it initial recon ALJ denial because that's her third in
mhm,
one application?
yeah.
Yeah. And then you would
You
be going to the
get
appeals council, sweet candy,
yeah.
if you're wanting
Yeah,
to appeal.
I think that if you're getting not denied, you should definitely talk to an attorney. Now, again, you know, not every case is a winning case, and you may have trouble finding an attorney. Some attorneys may say, "I don't think I can win that." So realize we get paid a percentage of past due benefits if we win. So if somebody comes to me and I don't think they've got a winning case, I'm not going to take it. So that could be an issue. But yeah, you can certainly appeal it with an attorney. And if you go to the appeals council, or really a hearing, you should have an attorney if you can get one. Um, but yeah, it is definitely wise to at least talk to somebody, or more than one person. Uh, Gently moving. Traditional Medicare with supplements is always better. That's what our person we were talking to, Karen, was telling us today. Advantage plans work okay. Okay, well, you're not the only person who believes that. That is a summary of what our friend Karen told us today. That traditional Medicare with a supplement is almost always better than Medicare
Yeah.
Advantage.
I think that the crux is when it is a person with low income that has difficulty affording the premium for traditional Medicare, which is it, what is it now? Is it like almost 180 a month?
I don't
Um,
know. Yeah.
and they can't get a but a supplement. Um, so I'm talking that people with lower income overall, and that's where Medicare gets its lure from, I think, because
Hmm.
yeah, you get less services, but you get coverage, and we'll even pay you. Like
Hmm.
the lures are there, um, and it's
Well,
well, we
Karen.
are all very frustrated today when we were talking about this, weren't we?
Yeah,
Yeah.
yeah. I mean, Karen, our friend Karen's comment was that the problem with Medicare Advantage, again, this is her opinion. I'm just repeating it. Is that it limits you as far as the doctors you can have, and that any procedure you might need has to be approved by an insurance company. Medicare Advantage is basically replacing Medicare with an insurance company, and that if you need certain things, you may have to wait more for it. So, whereas Medicare with a supplement maybe gives you a broader, scope of doctors you could see. I'm sure
Yeah,
there are other
and
people who feel differently, but that's
is
what
it
Karen said.
also where, like, with traditional Medicare and a sup, it's kind of carved in stone
Hmm.
that things are covered or not, as opposed to the insurance company having discretion, like we're not
Right.
covering that this week,
Yeah.
you know?
Although Medicare, I guess they probably have reimbursement schedules too. So not every doctor will take it, right? So I don't think doctors are required to take Medicare,
True,
which is
but
kind of
don't most
given.
of them do it? I always thought
I
most of
think
them
most of
did.
them probably do. Although, like I know a couple of one friend of mine, a couple years older than me, went to college together, and he's a concierge doctor. And I don't think he take. I think he basically is like, you want to deal with insurance or Medicare, you file it on your own. I'm not doing it. So yeah,
I have a few doctor friends that wash their hands of insurance. They do
yeah,
sliding scale a lot of the
yep,
time.
yep.
They're very, kind of, what do you call it? Grassroots, I suppose.
Yeah.
But
Well,
they're
this
like done
this
with
guy
it.
that like I said, this guy's a friend, my friend. I mean, in fact, I know a couple of people who's doing like sliding scale or really free, because that's part of his his business model is he will give away, they call them scholarships, to certain a selected number of people, and he does that. But he's a very good doctor. But he's like because I was working, because I asked him about it one time. He says I was working till 11 o'clock at night filling out forms for insurance companies only to have them cut my what they're paying me. Because I get said enough. Got tired of it.
Yeah.
So he's like, I'm just doing it this way. People, they pay me a certain amount of money. They have my cell phone number. They can get me 24/7, and they can deal with their own insurance submissions,
I
and
love it.
it
It's
works
like
for
old
him.
school,
Yeah,
It's like
yeah,
old school.
yeah. I
It
mean,
sounds really cool.
um, all right, Carrick. This is another one of my clients, or I think was here earlier. I noted a couple other ultrasound techs. That was a sonographer. Basically, your question: what V came with jobs? Yeah, I don't recall that there were any jobs. That's what it boils down to. I don't think that there were any jobs that were transferable from an ultrasound tech to sedentary. Doesn't mean, again, I'm not a vocational witness. It could be there are, but I don't recall that being the case. So that was my experience, and that's what I think we'll argue in your case as well. Um, and I can certainly look, but I don't think there are any. All right, got a fully favorable age 46. Good for you. Full VA benefits, even though you've got full VA. That was another thing we were talking about earlier today. Is some judges, there seems to be at least there's an argument out there. I don't know if it's true or not. Some judges feel like, well, if somebody's getting VA benefits, why do we need to give them Social Security as well? They're double dipping. Um, and this gets to the whole question of, are some judges kind of approaching cases with the idea of the person is disabled, and I'm going to look for evidence to prove that, or they are not disabled, and I'm going to, if they have to prove otherwise to me. So that's two very different attitudes. And one of the things I can tell you from my observation, there are judges with these really low approval rates that seem to have the attitude like everybody's faking it, prove me wrong, which I think is really unhealthy. Because and the other point would being, just because you're getting VA benefits, different standard of disability, that should have nothing whatsoever to do with
Yeah,
whether you
it's
qualify for
not.
disability.
That's like suggesting that suddenly Social Security disability is needs based, which it's
Yeah,
not. You
it's
bought it,
not
you paid for it,
either
and you
right,
also bought the VA benefits when you
right.
did your
You
military
served,
service. So that
correct.
infuriates me. That whole concept that could be happening.
Yeah.
You
Well,
know.
there was a very interesting post on the listserv today, and again, this is the first time I've ever heard this. Somebody posted that they had a hearing, and the judge sent it out for a post-hearing consultative evaluation, and then the lawyer gets an unfavorable, and then there's a hearing scheduled for like next week. The lawyer gets an unfavorable decision in the mail. Okay, which basically means it was pre-written. So the question here is, you know, what do you do? So basically the judge pre-decided the case without hearing any testimony. It is a second hearing, but again, if you ask for a hearing, theoretically you should be able to be heard on it. So everybody's response is that is clearly appealable, and
Yeah.
maybe the judge could be sanctioned for something like that. Now, I'm not sure we're getting the full story behind this, but if that's the case, if there's a written decision made before the hearing, that's a bit of a problem, wouldn't you say?
Yeah, and did they not even schedule a second hearing, or do they have it scheduled and accidentally sent out this
Yeah,
thing
that
got
was
leaked
that
out?
was that seems to be what happened. That they accidentally sent this out in advance of the second hearing.
Wow.
It's like, well,
But the
obviously
fact
that's
that he made a decision before the second hearing
right.
altogether is
And
bad
so,
to me.
so somebody's point was, well, what does the decision say about testimony? Because obviously, are they just making up testimony? They're referring, because hearings decisions will refer to testimony. The claimant said blah blah blah, but the evidence says that there may be some limitations, not to the extent of what they're claiming. So if the decision is referencing testimony that was never given, that's a bit of a problem for the judge, I would say. Now, what will happen, we don't know.
Or
If this,
misstatements of testimony. I mean, we,
yeah,
we get
yeah.
the audio. You guys probably don't get it, but and I wonder if that's going to change if one day like pro se claimants can have the
Yeah.
direct
Well, I
access.
mean, what I tell my clients is, we get the audio. In fact, they just upgraded the system. I don't know when it's going to come into play, but we get the audio. And I tell my clients, look, if you want me to get it for you, I'll get it for you in a couple of days, and I'll download it and I'll send it to you. In fact, Rodney, one of my regulars here, I don't see him tonight, but he had a hearing. He wanted the audio, so I downloaded it for him. Had to convert it from something called OGG format to MP3 format, and send it to him. So yeah, you can get the audio of the hearing. And I'll tell you that something else is that listening to the audio is very useful because sometimes during the middle of the hearing, you're so worried about what you're saying and what's going on, you don't really listen to what's happening. And when you listen to it again, you may get a completely different take on what happened, positively or negatively. But it's
Yep,
definitely worth considering.
for sure. The OGGs, I can play them right off of
If you have a
well, I have
player,
a
yeah, you
Mac.
can.
Somehow it
Yeah.
just comes,
hmm
thankfully, because there was a time when I had to do all sorts of weird,
Yeah.
like
Yeah. Shenanigans.
half the
Yeah.
time
No.
unsuccessful things. So
Yeah. There's a number of media players that will play almost anything, and but not every computer has those. And so,
yeah,
like I said,
it's great.
you can go online. There's probably a utility out there online, convert OGG to MP3, but you have to get the OGG file
Yeah.
first. So, okay. Um, let's see here. Teresa Bond. Okay, very good question. Why don't they consider chiropractors as doctors when reviewing medical records? They consider chiropractors alternative medicine and not acceptable medical sources. Um, what do you think? Why do you think they don't give chiropractors any love?
Who may?
Yeah,
Because they're not MDs or GOs.
yeah.
You know, they're just
But they
not.
also, but they give nurse practitioners. They consider
Yeah, I
that.
guess because they're trained under the, there's a bit of a monopoly there in the mythical
Yeah.
profession.
Well, you got They don't give acupuncturists or Eastern medicine or
Or
naturopaths,
massage.
right? All that kind of stuff. I mean, what they will now, if you go to a chiropractor, it is relevant that you sought treatment. What they
Mhm.
won't do is they want the chiropractor diagnoses a disc
Sciatica.
issue or sciatica. They won't consider that, but they will note that you went to treatment. So it does have a little bit of value. But I think this is the American Medical Association's lobby, basically to
Yep. I
keep the
wouldn't be surprised.
chiropractors out.
And they can't diagnose, so they can't do that first step, but
Mm-hmm.
their observations and everything else, I think, in terms of severity, are considered. They're just not the acceptable medical source for that other stuff.
Right.
I always,
You're not gonna win a case with a chiropractic
yeah.
opinion.
I mean, I always talk to my people about, getting physical therapy,
Mm-hmm.
if their doctor recommends, or if they think they should ask if the doctor recommends, because that seems to be taken, when it's prescribed, um, and there's a lot more meat to them physical therapy
Yeah.
records. So I kind
No,
of
physical therapy that can be very helpful. Physical
it's one
therapy
of my
records can be
favorite
very.
forms of evidence.
Yeah. Yeah. But yeah, chiropractic is, and honestly, you look at chiropractic records, there's a lot of talk about subluxations and all the stuff. I think that, look, I've been to chiropractors, and a good chiropractor can do wonders. I mean, they really can do wonders. I do think in the chiropractic field, there are some, maybe not as much as many more, that, I've seen chiropractors talk about, well, we can sort of substitute for family doctors. Chiropractic is what it is. I mean, it's not the same as going to a medical doctor who has the option of prescribing medications or ordering surgery or things like that. So it is a alternative form of medication. It's non-invasive, which is a good thing, but I don't think I would substitute it for maybe in addition to regular MD, but I
Sure,
wouldn't substitute
absolutely.
for it. Yeah. Yeah, I remember this is going back many, 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 many years ago. When I first started practicing law, I was with a firm that did personal injury work. I was there for about a year. There was this chiropractor, and he was doing adjustments on like 3-month-old babies. And I'm like, really? I mean, come on. I mean, that was just like, I don't think that makes any
Oh,
sense. But
that's nasty.
yeah, it was.
That's
I was
nasty.
like, I'm like, really? 3-month-old babies? Not that. Okay. All right. Jen posted the 7-9. So we talked about, like, if you're going to ask for benefits to continue, use the SSA 795, or if you want to, let's say, write a statement about that you had a medical consultative evaluation, only less than 15 minutes, doctor to do anything, you could put it on this form. This is just sort of a utility form you can use for any real purpose, and I use it a good bit just for like if I'm asking the court to or the Social Security to consider a late filed appeal, I would use this form. Sounds like you got some dogs back there. Steph, is that your dogs?
Yeah, can you hear him?
Oh, I can hear him. Yeah, that's okay.
Is it
it's
loud?
not
I have my headphones
my.
on. I wasn't listening.
I can hear it, but that's cool. Yeah, I had Sadie, my doodle, was here a couple times.
Let me
She's
open
been
this
here.
door.
Yeah, that's fine.
All right, stop. Oh, you're not coming in here. Why don't you go on out? There you go. There's 3 of them.
Oh boy.
2 bigs and a little small.
And a little one. Okay. All right. St. Louis Grand is one of my regulars, and he says, no questions today, just saying hello.
Saying hello. Good to see you, Louis.
Okay. Mike Rodriguez. Hello, Jonathan and guest. I had a disectomy and have issues with my legs falling asleep. Hearing later in July. Hopefully, what are my chances of winning? Again, it's hard to really answer that. I mean, how old are you is one question. What does the MRI say? We got dogs in trouble there. What does the MRI say? What do your doctors say? Why are your legs falling asleep? What is going on with that? I think it's just going to depend on a lot of different things. But having a disectomy, obviously is a significant medical procedure, and now you're having, problems with your legs falling asleep. That says that the disectomy was not entirely successful in solving the problem. So, I would want to know what the diagnosis is. Okay, you got the dogs out doing different things.
We think.
Okay, and the other thing is, when did you have your disectomy, and how long has this leg falling asleep been going on? It's been going on for a year, for 3 weeks. So a lot of questions more than answers here. So I can't really answer that without knowing, again, how old you are, when the disectomy was, how long the legs have been falling asleep. Do you have a diagnosis? Is there any treatment that's been given? What is the doctor saying, et cetera, et cetera. Okay, Rick Torres. Answer to that is no. We just got something from NASCAR today that the new SSA verification identity rules, current applicants or disability applicants are not subject to it. This is for apparently retirement only.
I just did something on this. SSDI applicants, no, it doesn't apply. SSI applicants, no, it doesn't apply. Medicare, it does not apply. It applies to retirement, spouse, survivors, spouse, and child. So dependent benefits, and so that was good.
And there's a lot of court challenges. This may go away, by the way, but we'll see. And so Mike talks about, again, this is for prior question, issue standing and walking. And again, all these things are significant and might reflect a complication or an unsuccessful surgery. But again, without knowing details about when the surgery was, how often you have this, what the doctors are doing, we can't really answer the question.
Can I bring up something about the way Mike described? I have issues standing, walking for more than 30 minutes. Always, if you've mentioned this before, Jonathan, about, make sure when you say a number that is accurate. 30 minutes can be a mile and a half.
Yeah.
And someone could walk a mile and a half in one go. Some might not consider that highly limited. Yeah. So you want to be careful when you say minutes. Get out there and do your 30 and then see how you're feeling.
See if you can do it. Yeah. Now, in fact, this comes up. People say, well, I could lift 20 pounds. Yeah, 20 pounds is a lot of weight. I mean, I could lift it. 2.5
gallons of milk.
Yeah, it's a lot of weight, especially. Plus, if it's awkward, I mean, it's a lot of weight. Yeah. A lot of weight. Melanie Frost, is it better my attorney get medical records with them directly? SSA since you're responsible. I think normally, when you apply, you're providing this information to Social Security. Let them get them. That's what they're supposed to be doing. Your attorney can submit them electronically, which is a benefit because you don't have to, mail them in or fax them in, things like that. So, my thought is let your attorney submit them. But
And
what do
not
you
only
think,
that,
Steph?
the SSA has a duty to order them at the
Yeah,
initial and recon in particular. And you don't necessarily want to send duplicates.
right.
I know the duplicate rule, does it apply primarily at, I know it applies at ALJ. I just
Yep,
don't know if they apply it at the lower levels, but
I think so. I mean, yeah,
I
and
take
they really,
advantage of that SSA.
yeah,
They get them, they pay for them. You don't have to do
right.
that.
Let them do their work. I mean, I'll tell you, my practice, and Jen will tell you. I mean, when we at Initial and Recon, we are constantly reaching out to the adjudicators, get these records, especially with the health information technology. They get them almost immediately.
The
Let them
HIPMers.
do it. Let them do it,
Yeah.
and let them deal with the deduping, because they do not like duplications. I had a judge, chew me out over that. I mean, I'm not going to say more about this particular judge, but he was just, you call this extra work. I'm like, well, we wanted to be thorough. The problem, I'll tell you, was the simple problem is that the records that Social Security had were not complete. So, and they were, I had the records, and you know there were some pages that were not there, so I resubmitted the whole thing, and he was not happy about it. Well, tough.
So
I
he,
mean,
and they even say if it's a different,
page
I
the
don't want to say
page
the word
numbers were different.
version, it's
Yeah,
not
yeah,
duplicate.
right.
Like if you have it from a record from the portal, let's say
Yeah,
it's the patient portal,
right, right,
and you have the official version that was sent, which is completely different page numbering.
right, right, right,
One could be, it could be the same, largely the substance, but that's not the issue. It's rather it's
right.
actual duplicate. So I think that judge might have been a little out of line.
Well,
But
he is out of
yeah.
line with just about everything, but that's a whole different story. Okay.
But also one other thing that used to happen, this is for Melanie. Um, I have found that sometimes, and I can't speak, I'm sure not all adjudicators do this, but I've seen it many, many times where if if you send in partial of Dr. Jones, because you have partial, you have them in your possession, you're like, I just want to get them there so they have
Mhm.
something. Sometimes they won't go order the full set, and they think, and it's not like they tell you, I'm not going to order it because you sent us some. They're not going to say that. It's just almost like maybe a mindset like, all right, we have Dr. Jones because the claimant sent them in. All right, we're good there. We don't have to send a request for those. And next thing you know, all they have is what you sent, you
Mhm.
know. And they also sometimes will do second requests, second HIPMers, right, as well.
Yep.
Um, and we, as lawyers, we get to look in there and we can see what's come in and what hasn't
Yep.
too. So,
Right.
your lawyer can do that. I don't think you should be. I mean, I don't know how your lawyer is handling it. I don't tell my
I
people
think
to
I
send
agree.
in
We
stuff
shouldn't
to
be doing
directly
it.
to SSA ever,
And I
ever.
think that the other thing is, I think that SSA is sort of automatically suspicious about claimants sending records in because they think they're going to be scrubbed. As an attorney, let's say there's a reference to, you know, using cocaine, or there's some reference to malingering,
Oh,
and you pull
redacting
that
it or
page
something.
out, and right, and so as an attorney, we can't, we're not, we
You
can't do
won't
it
do it.
ethically. We won't do it. So they probably feel more comfortable with attorneys sending it in. But I would
Point.
have your attorney
Yep.
do it. Yeah, yeah.
Yep.
All right. Brooke says, "Thank you for the advice. You're very welcome, Brooke." Um, Angie Vasquez.
Angie.
Okay. Uh, Today, when calling the office, I assume you mean Social Security office. A lot of the old phone prompts and info messages are gone. Just let me press 1 for English, 9 for rep,
Hmm.
but after 5 times callback due to full queue. So they may be working on the phone system at Social Security because it's a big mess right now. But
I am curious if a lot of those prompts are gone, info messages. Nothing is more annoying to me than having to listen to four
oh yeah,
minutes of info messages.
right,
They've been
right,
doing this for years. Like, it's
yeah.
like,
You
stop it
suspect
already.
fraud, right,
Give me your menu items and let me
right, right.
move on to my direction.
Yeah. No, I had, in
Maybe
fact,
that's going to
I
be
called.
something improved.
I mean, we could hope. Yeah, I had mentioned I had this case was approved on the record, so the judge's office called me. So here's the number to call back. So I called the number back, and I get this, like you said, 3 minutes of if you suspect fraud and this, that, and this, and finally, if you know your claimant or if you know your party's extension, press 1. and I do, and then enter the thing in there. But yeah, you go through this long
Oh,
5 minutes, just a waste of time, and you can't bypass it.
infuriating.
It's just
Yeah, I
annoying.
think another one is what was it? Did you know you can do all sorts of things
Yeah,
online at ssa.gov? And they go through, I mean,
yeah,
it's just,
all this stuff.
I don't know, maybe I'm
Yeah,
just an impatient person, but I want to get my stuff done
no,
and
it's a
don't
waste
hold
of
me up with
time.
this.
Yeah, with this BS. They tell you, or they say, if you don't have a touchtone phone, call our 800 number. Yeah, that's going to do a lot of good. I mean, three
Yeah,
hour
the
wait and
800
get
number right now.
the 800 number. That's a good use of your time. I would just
Well,
tell
ever
everybody
since
here, yeah,
when they
don't do
took
it.
off when they took off the phone numbers
Hmm.
off of the online, and this happened sometime after COVID, I guess,
Yeah,
because people were, lockdowns and stuff, they were
yeah,
calling too much, and they turned all those that location finder place that you and I were talking
yeah,
about before. They so you put in the social and you get the office that's closest to you, and they took out their own number and gave everybody the 800 number. No wonder why the 800 number is bogged down, because no one's answering the number at the field.
right,
And not all field offices did this. So this was clearly a
right,
local
right.
decision by individual managers, I guess.
Yep,
And because some still have their number and did, and some closed their number right off, said, "Ooh, we're not having people call us. They can call that 1-800 number out in Timbuktu."
right.
And
And
now
wait
that 800
4 hours. Yeah,
number is like got the whole country calling it. You
that's
know,
crazy,
it,
crazy.
it, it was such, I don't think they
Yeah.
should have had that kind of
No, 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 no.
discretion.
Well, and look, the problem is a lot of people need to talk to somebody, and I realize that that's out of favor now, and everybody uses call agents from all over the world and so forth. But Social Security, somebody just need to talk to
It's
somebody.
different. It's different. Sure.
Yeah. Okay.
Janelle.
Okay. My favorite duo, Joy. Um, you mentioned that my 5 month wait could possibly be due to a supplemental hearing. Is my lawyer supposed to inform me if so, or Social Security themselves? Do you understand?
Yeah. So what's happened with Janelle, she had a hearing and she still hasn't gotten a result 5 months later, no decision.
Okay.
And we went through a bunch of possibilities.
Okay. One is
It could
possible
be that
supplement.
he sent out because sometimes, like, unless I go into the ERE, I won't know that the judge um, sent out interrogatories after hearing, because
Hmm.
I didn't get them in the mail.
Yeah.
Right? So, and in one particular case that I have right now, we had a hearing in, I want to say it was October or November, forever getting a decision. Still haven't gotten it. So we're talking now more than 5 months, right? Same as you,
Yeah.
Janelle. Um, but I went into and usually I don't like when they're going long, but this is a younger person too, someone in their 40s. So I went into the ERE and
ERE,
um,
by the way, just so you know, is Electronic Records Express. That's where we go. We can
yeah,
look at your
e-file
your file.
basically. So the
Yeah.
people go,
We can also look at your file too.
yeah,
That's what we
there.
see.
So I think was that what I did first, or I did that after? I got wind that there is another hearing scheduled,
Hmm.
and we might have. I got wind of it. However, I got wind of it, I'm not even sure. Um, it could have been going in, or I think I found it out before I got it in the mail. So the judge scheduled another hearing, and when I got I think it has to do with that 24-3 change rule, because it says
Hmm.
I have to
The look back, the job
correlate
look back.
yeah, I'm like, does he have to do that? Could he have denied her, or is he thinking of awarding her?
Yeah.
Which
Who
would be nice.
knows?
So I don't know,
Which would be
but so we
nice.
have a hearing in June, hearing number 2.
Yeah.
So no
Yeah.
decision there either, Janelle. That's why I said it could be they're putting up another
Yeah.
supplement hearing, or it could be he's getting additional evidence. It's just that it would be nice if they told you, but if
Yeah.
they're
I
doing that,
actually.
or they
Yeah. I
could be
have.
slow.
Yeah. Well, I had a case that was my least favorite judge locally here, and I used Assure, and I used something called Chronicle, which are both it's kind of the same thing, but it just gives me sort of a double coverage. So it gives me status of my cases. So I saw like in mid-February the case was denied, no decision, didn't get it. No, nothing in ERE, nothing anyplace. So we started calling because I'm like, well, I didn't think it was a case I was going to want to appeal, but I needed to give my client the option. But I can't tell them anything. So finally, the decision got posted today, with today's date on it. To be fair, but it got posted today. I had been originally made February 15th, and it finally got posted today because we had to call to find out what was going on. And of course, it was in a denial, but this is, a judge that denies everybody. So
Was
I
that a
said,
tech glitch, you think? Like it just
I think they just didn't publish it. And,
someone dropped the
theoretically,
ball?
if we hadn't followed up on it, and let's say 6 months had passed, and then we started, then at that point somebody starts calling, they would, oh, this was mailed out. They would, I'm sure that's the argument they would make. This was mailed out. What are you talking about? Well, no, it's not. It's not. It's not in the file. That
Right.
would have been grounds for appeal. The problem is, with the remedy would have been, let's do another hearing, and or the judge needs to issue a decision now. Like I said, the case was not strong enough, in my opinion, to really support that.
Hmm.
So we just got to take care
They
of
had
it.
I had a glitch at the OHO recently where a person who had a case remanded from federal district court went back to Social Security Appeals Council, who then remanded it back for a second hearing with the
Mm-hmm.
judge, as per you have the FDC order, have the Appeals Council letter saying so, and got me on board at that juncture. So this is a few months ago. And I did get connected and I did get into the ERA and I got so far, I download the whole file and everything because now I'm going to start working it up for this
Mm-hmm.
second hearing for him. And next time I go into the ERA, because I go in there a lot on my cases heading to hearing, I'm like always in there checking things.
Mm-hmm.
And there was no case. It said there was no case. There
Mm.
was no electronic file for him.
Just disappeared.
It disappeared. I called the field office, got through, and they said, "Oh, it's waiting. It's up in federal district court waiting a decision." I go, "No, it's not." I go, "I'm
Yeah.
looking at the,
Mm-hmm.
November letter from the FDC, and then also I went to your appeals council, and your appeals council remanded it back to the judge on December whatever." And she's like, so then she dug deeper, and she goes, "I do see something weird here. Okay, I think she goes, I think you have to call the Office of Hearings Operations because I said, I go, it was at the OHO properly."
Mm-hmm.
And then it just blipped out. So I contacted them, and they did get it back in order within like 2 weeks.
Yeah. Yeah.
Yeah.
That's one thing. When things flow smoothly, it's great. But if there's a glitch someplace, it can become a nightmare to try to find a person who
It
can
could
fix
take
it.
your whole day or enough
Yeah.
minutes out of your time
Yeah.
every day to make
Oh,
up
yeah.
a day,
Yeah.
2 or 3 of your life. Yeah.
All right.
I would
We
say
got
don't
about
get a cog in the SSA wheel. Just don't get a
Right.
cog. If things
Right.
are moving, don't
Yeah.
stick your stick your
Oh, look,
foot out.
I have had a case where it was a client who had a serious medical problem, and this guy was literally emailing me 3 times a day, and I'm writing and he was very anxious about it. I'm talking to the adjudicator, sending stuff in. Case finally gets approved. They didn't pay me. Okay, they just didn't. So I called up. Oh, we made a mistake. Sorry. Like, what? Can I file a fee petition? Well, you can do it, but money's already been released. Sorry, never got paid on it.
I just had one. Funny you should say. It
Yeah.
was actually awarded a couple years ago. It was awarded after this is discussion about fees, guys. So I know it's not really about you guys, but
Yeah.
the the fee at the time the decision came down, which was on one of the lower levels, it wasn't ALJ, was $7,200. The case when we started together was $6,000. Remember, they changed in
Yeah.
November of whatever year that was, and I think 22. And I know in the decision letter they had the wrong. Oh, we withheld 6,000. Da, da, da. And I sent them a letter at the time. I just kind of sent it out, being like, "Can you please correct this? The key fee cap is 72."
Yeah.
That was like a year and a half, 2 years ago.
Yeah.
And I, hadn't thought about it since because you really don't have time to always be babysitting those things. It was a $1,200 difference. They got somehow I guess maybe a little over a week ago now, they contacted her, sent her a letter saying, "We made a mistake, and you owe $1,200. You're basically overpaid on your fee because another $1,200 should with her." And I believe she's sending me a check.
Wow.
So,
Good. It's
otherwise she could be stuck with an overpayment.
Yeah. Yep.
So I don't get that cog in your wheel, and I'll happily get my full pay.
All right. So we got 10 minutes left here. Treating doctor on network for a year, but I've been using my meds while I search on the document that I fit short form. Well, first you say SSI. SSI is a form of disability, so make sure you're using the right terms. Is it SSI or is it SSDI, or is it using
Really
this kind
big
of generic?
difference.
Big difference. Okay. Um, well, I mean, you're using your meds, but you're not getting treatment. So you can certainly
Oh,
put that on there, but it's a little problematic. I mean,
yeah.
you're better off having treatment. So, you know, again, I realize it can be hard to find doctors, get appointments, but I'd make that a priority. I would just say.
Yeah, a year is a long gap, I think, in the
Yeah.
SSA world.
Yep.
And sometimes I say, get any doctor right now
Mm-hmm.
while you look for your dream doctor. Like
Yep.
for the sake of your case, um, I really think sometimes you just have to be, it's like anything else.
Yep.
You got to feed yourself. So even if
Yep.
it's not filet right now, get the doctor's appointments
Get
while you
something.
search for your
Correct.
specialists and the ones you want.
All right, let's kind of zip through some of these.
Yeah.
Michael Jennings again. Do failed job attempts for work with wages less than trial work hurt? In terms of just in general, failed work attempts, I think show you're trying to work, and I think that helps in general. You
I
know,
agree.
yeah, I think it shows you're motivated. Okay, Joe Menick, I'm going through a CDR of MS, not working for a while. I have MS likely. Well, you don't get approved. I mean, CDR is going to be,
Interesting.
are you able to continue to get benefits? Um, MS is a progressive disease, so it's not likely there's going to be spontaneous improvement. I think it's probably unlikely they're going to terminate you, or that you. Well, of course, if they've already moved to terminate, as long as you've got evidence that shows your MS is, continuing to be a problem for you. But again, it just doesn't sort of automatically get better. So I think you're probably in pretty good shape there. Although again, you got to go through the process. Um,
Yeah.
all right, Roy's Place. Oh, very good. Thank you, thank you, Roy. I appreciate that very much. We try to, yeah, we like to share what we know because there's a lot of misinformation out there. Fowd. After last summer, the judge on my case, severe impairment can do light job with 30%. So yes, you got to basically realize a lot of the stuff you see in these written decisions, it's form. It's boilerplate. So yes, severe impairment is a term of art in Social Security. There's something called a 5-step sequential evaluation process, and step 2 is severe impairment, which means it's diagnosed and it's significant, but it doesn't mean it's severe in the sense of it's disabling. So
It
you can
causes
have
limitations, right? But
yes,
not
right,
necessarily to prevent all
disabling,
jobs.
right, right. So I wouldn't read too much into that because severe is like I said, it's just a sort of a threshold you got to get past.
And it's a
And
very
obviously,
easy one to pass here
yeah,
for most
yeah,
things.
yeah. I mean, at one point, it was anything was considered severe. Now there's got to be some treatment, some evidence of something, but it's a pretty low standard here. And a 30% approval judge is pretty low approval, unfortunately. Um, well, I get back paying first payment before I get award letter. Partially favorable win of the vote hearing with SSI lady and assets already too. So you have an SSI case. Um, Usually you get the award letter first. It could be within a few days of each other. They've got to do an income resource interview. If you've already done that and they've already made the decision you qualify for SSI, there's no offsets. You should get it pretty quickly. But the award letter theoretically should come first, but sometimes it misses it by a couple of days. Um, George Graham. Um, okay. How are we
Hi,
doing,
George.
George? Okay.
To see you.
Independent Music Group. 57-year-old man diagnosed with bilateral nerve cirrhosis. Um, Again, I think that it depends. How old are you? How severe is it? I mean, you're 57. That helps. How bad is it? Mild stenosis, severe stenosis? What does it cause? Is it cause numbness in your arms or feet? What is the effect? What is the effect? What is the treatment being suggested? What is the treatment you're getting? These are all questions that would help answer that question. Um, um, Steph, do you understand what he's asking here? What
Hi,
medical
Kevin.
approval?
What medical approval will a 59-year-old would be for after? Are you looking for the chances of a medical approval for a 59-year-old after knee surgery? I always say they don't give us stat books and they don't give us any of the information on ages and who wins, and they certainly don't have it broken down by impairment. Um, but 59, I mean, is it only your knee, Kevin? I mean, I'm breathing down the neck of your age, and other things ache too. How's your back? Can you stand? Okay, standing is probably not good because you have the knee surgery, but could you stand for, you know, 45 minutes at a time, right? I mean, there's so many ways to look at it. I mean, you're at a good age and the surgery is good, but are
Hmm.
you limiting your case to just that, or do you have other impairments you haven't mentioned because they don't bother you as much?
And also,
I
was a
would
knee?
be,
You may have said this. Was the knee surgery successful? Did it? How long were you out? Over what period of time were you not able to walk or stand?
yeah, I
So
don't
it
think
was
he's
just like.
had the surgery yet, right, Kevin?
Uh, but I'm
Right?
saying the question
Yeah.
is, when did his knee become a problem? Was it like 3 months ago? Was it 3 years ago? So
Duration.
there may be a closed period here. You never know. Okay. All right. Let's kind of go through some of these quickly. I'm not ignoring anybody. Just we only have a few minutes left, so
Yeah.
want to get them to them quickly. Okay. Aunt Scary Sherry. I love the name. How long to get a recon to the hearing? Recon normally takes about 8 or 9 months, depending on where you are. It could be longer. Um, that's on average. That's what I think. 8 or 9 months, ten
Yeah, I
months.
think I have some really long ones, and then I have some real quick ones, which makes me think they didn't even look at all the records. So
Yep.
it's like,
Okay. Salim, I've been diagnosed with a brain injury with facial paralysis from trauma plus high blood pressure, diabetic and hernia discipline. Take lots of medications. You're 55. Well, again, facial paralysis from trauma, uncomfortable. It's not something you want to have. But how does that affect your work capacity? That's really the question. If you have, let's say, Bell's palsy, an example of facial paralysis, that may not prevent somebody from working. Now, maybe it interferes with speech. It may eliminate certain jobs, but it's not going to eliminate, certain
mm,
back office or factory jobs, things like that. High blood pressure, again, what are the symptoms? You have headaches from it. You have other issues that arise from that. Diabetes, type 1, type 2, under control, not under control, insulin dependent, non insulin dependent. Hernia, has it been, how bad is it? Has it been treated? The medications, what are the side effects? So you see, you're giving us information, which is helpful, but there's a lot more that we would need to really be able to evaluate it. And the brain injury, you know, closed head injury, what does that mean in terms of your functioning, your emotional stability, your memory, your ability to, formulate thoughts?
mhm.
So there's a lot more questions than answers here. So again, I want you to see we're looking at this through the lens of how this all affects you at work, as opposed to, diagnoses or a listing
Right.
of potential
How do they
impairments.
functionally
Yep.
prevent various things? Like, does the
Okay.
diabetes come with neuropathy
Yeah.
too?
Yep.
That can be big.
Yeah. All right. So this is I want this question because I get this a lot. I'm on the third step and just finished. People always talk about, and I guess on the my Social Security thing, it talks about step 3, step 4. Does that mean anything? I don't know that it means anything to me.
Well,
Step
I
3,
think
step
she's
4.
talking about the sequential evaluation process because she says I'm on the third step and just finished going to SSDI disability doctors.
No, I
How
don't.
long will
I
be?
don't.
So
Yeah.
I think she's talking about she's still in the DDS versus that other nonsensical,
Yeah. I
like you
think this is
said,
the nonsensical one.
mysA.gov, where they're telling them you're in
Yeah.
step 4.
Right. That's what I think
They're
this
not in
is.
this. Like
That.
she's talking about the sequential evaluation process, which is the more meaningful
Yeah, yeah. I
arena.
don't think I disagree with you, but I think she's talking about just what they say in the My SSA. But we'll talk about both briefly.
Oh,
In the My Social Security, they'll say you're in step 3 or step 4, but what does that mean? It doesn't mean anything. It's just made up. They just they or
okay. So you think with the My SSA, see, I thought she knew she was in step 3 because of where she's medically
well,
at in the
step 3
DDS.
is do you meet a listing, right? That's step 3 of this.
Well,
That's part of the
then it's
analysis.
also about your RFC, so they have to have gotten your medical records.
Hmm.
Well, for the listing too, right?
Yeah, yeah.
So, but your point is well taken. If she got it off of the SSA.gov site, are does the DDS report in and say we're on step 3 or step 4? I didn't think so. I think
No.
that when they talk about steps in myssa.gov, I thought it was about those nonsensical internal at the
Yes.
field office
It's
area. The ones
it's
that
to
mean
try to
nothing.
keep people from calling and complaining. That's all it
Yeah.
is. Doesn't mean anything.
Like they're
Okay.
giving them anything meaningful, but they're not.
Yeah.
Yeah.
Okay. Okay. So somebody commented that her son got approved in December 23 for pulmonary arterial hypertension, very serious condition, listing level 47. The CDR was written in the approval letter. Okay. So it does happen there.
That's good.
Yeah. Okay. That's helpful. Okay. All right, so let's get a couple more, then we'll call it a night. Back pain case, tethered cord surgery, spinal stimulator. What the scan 50. So you've got, I think it looks like, Jeff, you've got a lot of stuff going on: spinal cord stem, bone density, scan, severe osteoporosis. So these are things that are likely going to generate some functional limitations. Again, you'd want to sort of tie each of those things to a specific functional limitation. But on the surface, it'd be, if you were 58, it would be better, but 53 is still, I think, pretty significant there. I think there's probably a pretty good argument here.
Yeah. I mean, spinal stimulator too kind of goes to how
right.
chronic that pain is.
Okay. Okay. What happens if the hypothetical leads to one job you can do, but it's listed as an EM? Do you know what the emergency? I mean, EM 24027 is an emergency message. The V further explain the jobs from the modern era. Yeah, the ALJ could, that might give you grounds for appeal.
Mm-hmm.
So I mean, ALJ can do what they want to do, but usually if the realize the judge is going to ask more than one hypothetical. This is one hypothetical. There may be others. If a judge wants to look at the end of the day, a judge wants to approve you, he or she will approve you. Judge wants to deny you, they'll find a reason to deny you. I think when you start getting into, kind of the real granular, this job and this, vocational expert methodology and so forth. Yes, there are people who spend a lot of effort and those, can be successful in getting a case remanded. We were talking about this earlier today, Steph and I. It's better to have a really strong case than to try to win on a technicality, because they'll find reasons not to approve you. What if you go through the whole process, find out that the technicality was not correct, that the judge used the wrong, the VE did not go through a methodology properly, goes back to the judge, does another hearing, finds you non-disabled again.
Corrects the technical thing and is still finding the same merit.
Right.
Yeah.
Okay.
Your evidence is really what's going to be important.
Yeah.
I always say just that is the thing you have to focus on.
Okay. All right. This is a good, interesting question. Silver Monster says, and we'll have this one more. Okay. 10 random people apply for SSDI through initial recon and hearing. How many out of the 10 would ultimately get approved? Realizing every case is different. 6 out of 10?
Well, is it well, yeah, if we're going to go by
because we have to go by the recon. I mean, I've not seen statistics that tell me what percentage of people denied an initial file for recon and then what percentage go to the hearing. I would guess probably anywhere from, when all is said and done, over all of it, if you looked at the entire statistical, spreadsheet or whatever,
crunch the numbers.
You crunch the numbers, 50-55% of applicants are going to eventually be approved. That's my guess, something like that. But that's purely.
I'm just going to defer to you because I can't even
think about it. I could be completely wrong.
Yeah,
but
I'm thinking about the flow chart, but like you said, that depends on if 38%, and we're using these old numbers, right? And I'm just kind of trying to remember what they were. If 38% went on recon, and 15% went on, 38% went on initial, 15% on recon, and that was like whatever year that was, like 3 years ago.
Right.
Now, of the 62% denied on initial, how many of them went on to recon to make up that 15%, right? That's what you were kind of saying, like we don't know.
Yep.
Which would tend to make you think it's a lower number, right? Like not.
Yeah. But 35% of applicants get approved at initial, and then you start going from there. What percentage recon and hearing? I'm guessing. Yeah. Probably 50. I'm guessing 50, but who knows?
I'll
Um,
take it.
yeah, that look. I just wish I could find the right 50%. That's who I want to represent. Okay. Let's see here.
Nice to see you, Virginia, by the way.
Okay,
Thank you for
Virginia
your
Gomez.
hello.
Okay. Okay. All right. So let's. All right, we got time for one more. Okay. Let's see if I'm trying to find a good one. Okay. Okay, we'll just take this one here. With Doge trying to kick as many people off as possible, would that be a good time to take it to work or something to that effect? Um, I do think that there's going to be an effort to try to, um, you know, do reviews and get people off because it's hard to get an attorney to deal with the continuing reviews. Um, Ticket to Work has traditionally not been a very effective program, but I think if you can try to work, you should try to work. Um, I wouldn't let what's going on in Washington, change what you do. I mean, I think you got to, if you can try to work, try to work. But I mean, at the end of the day, if you're disabled, you're disabled. I mean, there's a lot of talk. It's going to all settle out. We don't know what's going to happen, but I think that people are thinking that, that there's a target on Social Security. I mean, yeah, they're trying to reduce the staff. They're trying to reduce the money going out. But if you're disabled, you're disabled. I mean, so far we've seen nothing to suggest the program itself is in jeopardy. I do think there will be more reviews. I think younger people in particular are going to find it, younger being under 50, you're going to find more reviews there. But, beyond that, we just don't know yet. We just don't know. We don't know. Okay, let's do one more. Okay. Christina, you're late, but I'm glad to see you. You're here every week. Okay. Um,
Hi,
okay.
Christina.
Okay. All right. Now I'm going to take issue with Virgo Blue. There are too many people who can actually work. Where does that come from? I mean, this is something you hear kind of on the street. All these people they're faking it. I'm telling you, I've done this for 35 years. There are far more people who are legitimately disabled who are denied than the other way around. I mean, is there fraud? Possibly a little bit, but they make it so difficult. I disagree with your premise. I don't think that a significant percentage of people on disability can work, because I'll tell you something else that happens when you're on disability. You become deconditioned, and just because you haven't worked, and to try to gear back up to get to the workforce becomes really hard if you have a chronic medical problem. Your take, Steph? Would you agree with me on that?
I agree with what you're saying, and I think sometimes there's a misunderstanding about what the definition of legally disabled is. Some people think, well, if you're not bedridden, you're not
Mm-hmm.
disabled, and get your butt up and out. And that's not the case. SSD does not require you be an invalid or wheelchair bound, or they just require that you can't do a job full time on a sustained basis and not being absentee too much, um, not being slower than the average other worker too much, because then you're going to get fired for that. So it's a lot more detailed than what you think. And I think also they don't realize that it's not just one impairment that the person is usually
Mm-hmm.
granted on. Like a lot of people will say, my neighbor down the street, he's totally fine. I see him raking his lawn, and I know he's collecting whatever, whether it's SSD or SSI.
Mm-hmm.
And I have to remind them, like, do you actually know him very well? Like, do you know he could have, because it's very common, a
Mm-hmm.
mental illness that combined with he can rake for, so he could maybe do light work, but he's 60 years old. Light work by law lets him fall under a grid if he can't do his other job. Let's say his other job is inconsistent with panic disorder or schizophrenia that like there's so many
Mm-hmm.
things that people don't see and know about the other person. And I think that's why there's kind of a misconception that people who can actually work aren't. That the definition is not that you have to be with no legs or
Bedridden, right?
bedbound. Yeah, that is not that they don't make people be that demoralized before they win. And on the other side, the people that are getting denied are like, oh my God, they're making me be demoralized to it. Like, you know what I mean? So it's like
Yeah.
two different perceptions. but I definitely agree with you that I don't think it is really hard
To win.
to
Very.
prevail and to fool them.
Yes.
Um, there have been, we know, fraudulent schemes out there, some big ones that came to light, right, a few years back, but that's not the norm. That is definitely
No,
not
it's
the
not
norm,
the.
and we
Yeah.
can kind of pick them out very easily,
Yep.
you know,
Absolutely.
those of us that do this. So, and I don't know, I personally don't know a single, and never have somebody who would represent somebody who they didn't think was legally disabled.
Yeah.
It just doesn't happen. So
I agree.
I think you're overestimating what these people can do when you know the definition is sustained basis, all day, 8 hours, 5 days a week, on a sustained multiple months in a row without having excessive absenteeism. And
Yeah.
excessive absenteeism is more than like once a month,
Right.
you know? So you'd have to know the rules that apply to define someone as disabled under the program.
Yeah.
And then you
And
realize,
and and
oh,
just as a
maybe
final
not.
point there, I mean, the federal government has multiple disability programs. The VA has one. The federal retirement system has one. They all have different definitions. So, it just depends on, like you said, the grid rules. You may have the capacity to work, but under the grid rules, the law says even if you have the capacity for light work, if you're 57 years old in certain circumstances,
Yep.
you can do light work, which means standing and walking 6 hours a day, lifting 20 pounds occasionally. You're still disabled under Social Security's rules.
Right.
So, it can be a whole lot different than you think. Okay.
Yep.
We'll leave it there.
Exactly. That's exactly it.
That's a good way to end it. I appreciate, Stephanie, you coming on. Hold on for 1 second while I end
Pleasure.
this, and then we will do it again soon. But thanks to everybody. Hope you all have a really good week, and we'll see you next Wednesday.
Bye, guys.